Down in the shadows where the courthouse stands, a gavel cracks a fading hands. Judge Goulday whispered with a crooked grin, played the game where justice don't win. Free Rick Allen, let him go. Chains on the innocent, don't you know? When the truth's been buried and the lies unfold, the fire in the people burns hot and cold. Prosecutor Mickelin with his papers tied wrote the tale that never saw light. Twisted words in a room of stone, left Rick Allen to stand alone. Who will answer? Who will pay? The sun don't rise on a judgment day. Free Rick Allen, let him go. Chains on the innocent, don't you know? When the truth's been buried and the lies unfold, the fire in the people burns hot and cold. Officer Holman, eyes like frost, drunk on power, the line got lost. Lock the doors, keep him inside, for justice limps where his footsteps stride.
Hey yo folks, hey yo, welcome to this Saturday morning over in the United States. It is Saturday afternoon over here, and I should have started this on Wednesday already, but it's been a rough week, so I decided Saturday, and I will go as long as I can today. And with the Delphi Trial Transcript. Hello. Good morning, everyone. Good morning. Hello, Lisa. Hello, Katie, Erin, Factual Light, Denise Sells, April, Nicola. Hello. And everybody over at Rumble. Hello. I chose to not have this on X because I've noticed it might deflect people out of going here. So not going to. I will post some short form videos on X getting people over here, as I did with the Aiden Carney Turtle Boy. That stream, I posted a couple of videos on X directing people to that stream, and it kind of worked. So yeah, he looked tortured because he was. So welcome here. I'm going to go through. This will be the concept I'm going to work with here. I'm going to stream as long as I can. Then I'm going to cut up, for instance, I'm going to go through the table of contents. That won't be a separate video. But what I will do is the initial hearing, October 28th. That will be a separate video. Hearing held November 22nd. That will, and so on, the ex parte hearing, and so on, all the hearings. I will go through as many as I possibly can today, and then tomorrow, if I still have the energy, I will pick up where this stream left off, because to be able to go back and watch the things, I need it to be organized in that way that long stream and then every segment will be a separate video. That way it will be presented as, hey, what was that? I can go back and watch it myself. And you guys, if you see, hey, didn't he say something on that? Boom, everything will be up and running, because some of you probably know a lot more than I do. So that will be it's not to enhance views, but because it won't. But for people in the future who want to go back, hey, what happened? It will be out there. It will be out there for everybody too. And in the streams and videos, I will link to the whole transcripts Google Drive. So that is at least what I will attempt this to be. So, with that said, let's get right into it. Dun, dun, dun. Dun, dun, dun. Add to stage. I'm going to put myself up here. This is just the table of content, just so for everybody to get a grasp on how much this will be. Good morning, Jen. Good morning, Jen. So this is the table of contents. This is volume 2, which we will go through as much as possible today. Initial hearing held November 22nd. States exhibits. Hearing held January 13th. Ex parte hearing January 13th. Direct examinations. Cross-examination. Hearing held February 17th. And you see here, volume 2, we are page 130. Just 244 pages. That is... So you see, we have a lot to get through. It's going to be insane. So hopefully I can get through everything. Well, at least volume 2. But we have volume 3, volume 4, 5, 6, 7, 9, 10, 11, 12, 13, 14, 15, 16, 17, 19, 21, 'Yeah, that's why is... yeah, that's the sentencing hearing. So you see, for instance, volume 20, 240 pages. So this will be, well, to put it mildly, This will be you know I can't go through it all in one day. But I will go through as much as I can, and then, as I said, put it out in different videos to make it easily accessible. Why not? I why not, Nick? Not everything. I will start with volume 2, and if we get through it all today, let's start on volume 3. So that is what, yeah. Hey, Andy, good to have you here. Good to have you here. Now, Andy, if you want to show up, I will send you a link. I will send you a link, actually. Where do... Dun, dun, dun. There. Why doesn't Twitter want me to link? There. Okay, I couldn't just send the link. I had to write something as well. Did I miss volume 1? Yadzia? No. Table. Volume 1 is just table of contents. It's just table of contents. Oh. Now, I noticed already in the table of contents, especially if we're in the volume 1, I've been skimming through it a bit. There's one thing missing, and that is the ex parte hearing where Judge Diener decided, Rick Allen is going to be held in prison instead. That is missing. But I think I've already gone through that on a separate stream a while back. And it says, oh, you're doing a motions mode to go through all the effing state motions to preclude everything. Yeah. It's insane. Yeah, it was. Well, there was no hearing. Well, technically, it wasn't a hearing. It was an ex parte meeting where they decided that, which still should be in the appellate transcript. Because as you see, appellate case number 25A CR 00591. It should be in there. Because it goes to Rick's state, not only his state of mind, but how the bias from the state, bias by the judge, and bias by the state. Hi, Dave. Good to have you here. Good morning. So, folks, let's get through it. Appellate case 25A, State of Indiana, County of Allen, State of Indiana versus Richard. Honorable Francis S. Gould presiding. Well, record of initial hearing held October 28th, 2022. Oh. Appearances for State of Indiana, Nick McLeland. Defendant appears pro se. This is the Honorable Judge Benjamin A. Diener. Karen Allen, reporter. Proceeding. The court. Let's go on the record. This is case number 08C01-2210 MR1. Caption State of Indiana versus Richard M. Allen. Are you Richard A. M. Allen? The defendant. Yes, Your Honor. The court. Mr. Allen appears in person in the custody of the Sheriff of Carroll County. We're here for an initial hearing in a criminal proceeding. Mr. Allen, we are not here to determine any questions of fact. We're here to explain to you that the charges to which you're responding to, the statutes under which you're charged, your rights to an attorney, and your constitutional rights. Before we get to any of that, though, the court notes that on today's date, the state of Indiana filed a verified request to prohibit public access to a court record. Of course they did. Before Rick Allen was even, before the first initial hearing, the state asked, please, court, make it all a secret. Brett Gibson. And they were talking in this specific hearing here about him going to hire one. But at the ex parte, where they decided that Rick was going to prison instead of jail, yes, he had an attorney. Yes, McClellan knew he had an attorney. They didn't care. But let's go through this, and we will go through the ex parte meeting between Judge Diener and McClelland. A verified request to prohibit public access to a court record, and the court also, in response to that petition, filed an or entered an order which can be found on the docket. Court order sealing request and court records pending public hearing. There are a system of rules called the Indiana Rules of Court Rules on access to court records. And Rule 6 allows for the request to seal records and the records themselves to be sealed pending a public hearing. And so the court has granted that temporary relief and scheduled a public hearing on November 22nd, 2022 at 9 a.m. to determine if the requested court records should be restricted from public access as requested by the state of Indiana. The state of Indiana has the burden of demonstrating that it's entitled to the relief it's seeking, and the state of Indiana has to post a public notice in compliance with the Access to Public Records Act, and the court date and time for that hearing should allow for the notice to be posted and 20 days to pass, which is required under the rules. That covers some preliminary matters that are atypical. The rest of the matters are fairly typical. Mr. Allen, if you raised your right hand to be sworn, that's all right. You see? Okay, I see it. Yeah, this is because Rick Allen could only do this. Now, nothing of this is unusual in a case like this. Defendant sworn. The court, I suppose it's worth noting for the record, it does appear that maybe you have some protective gear on. The defendant, yes. The court, I don't own a bulletproof vest, but it looks like a bulletproof vest and some other things. And so the court notes that the defendant is in custody and there have been extraordinary measures taken to protect the individual. We're here for an initial hearing. Mr. Allen, do you read and understand the English language? The defendant, yes. The court, what is your age? The defendant, 50. What's your date of birth? September 9th, 1972. The court, what are the last 4 digits of your social security number? Defendant indicates. What should be here is his actual social security number and then blacked out, not indicates, in my opinion. What's your current valid mailing address if you have one? And here's his address. Are you under the influence of any drug, including alcohol, at this time? No, sir. The court, if at any time you do not understand anything I say, will you please let me know? Rick says yes. The court, you are charged in count 1 with murder, a felony. Count 1 alleges that on or about February 13th, 2017, in the county of Carroll, state of Indiana, Richard M. Allen did kill another human being, to wit, victim 1, while committing or attempting to commit kidnapping of victim 1. Without admitting the allegations contained in count 1, do you understand the allegations contained in count 1? Yes. Count 1 charges you under Indiana Code 3542-1-1. This statute provides, in relevant part, a person who kills another human being while committing or attempting to commit kidnapping commits murder, a felony. Do you understand the statute under which? Do you understand the relevant portions of the statute under which you're charged? The defendant, yes. And then they go through the sentencing terms and fines. And then again, count 2. Murder, a felony. And again, the statute and this possible sentencing. The court, those are the 2 offenses to which you're responding to in this action. We'll now go over your rights to attorney and then your constitutional rights. As you have the right to retain and be represented by an attorney in this case. You also have the right to proceed without an attorney if you so desire. And if you do not have the money, means, or property to hire your own attorney, an attorney will be appointed to represent you potentially at no cost to you. So there are 3 choices, only 2 differences. The 3 choices are hiring your own attorney, being your own attorney, or being examined to see if you qualify for court-appointed counsel. And so 2 of those, you still have the services of an attorney. One you hire yourself, the other the court appoints, and the third being you serve as your own attorney, which I've got 3 pages of dialogue I have read to you. The defendant, sure. To explain how foolish that is before I can allow you to do that, but I also must allow you to be foolish if you have your mental faculties, and that's your choice. Do you understand your attorney rights, Mr. Allen? Yes. And it says property. Yeah, you can take out loans based on property. I believe that is the thing. That because if they later, if it was, I mean, I've heard about cases where a defendant more or less gives their property to their attorney instead of actual cash. The court says, and do you wish to be examined to see if you qualify for court-appointed counsel? Do you wish to proceed as your own attorney, or do you wish to have time to see if you can hire an attorney of your own choosing? I wish to hire an attorney of my own choosing at this point. The court, you must retain counsel within 20 days, 2-0, because there are deadlines for filing motions and raising defenses. And if those deadlines are missed, the legal issues and defenses that could have been raised will be waived or given up. Do you understand that? Yes, sir. When the court find probable cause to support the charging information, it's set bond at $20 million cash or corporate surety. This is the first time anyone's heard that, the state included, and so that's what bond has been set at. When was that bond hearing, folks? And why isn't that here? I'm quite sure Indiana has bond hearings. I mean, or was this the judge just, yep, there it is, 20 million. Where's the bond here? Where are those papers? Where are that transcript? I don't know. Defendants indicated a desire to hire an attorney, which is defendant's choice. We'll now go over the constitutional rights, and then we'll set a matter for omnibus hearing and jury trial. Your constitutional rights are as follows, Mr. Allen. As a defendant charged in a criminal prosecution, you have certain legal and constitutional rights guaranteed to you. You have the right to speedy public trial by jury in the county in which the offense was allegedly committed, and the court is scheduling that trial for March 20th, 2023 as the first setting. Did you get that date and time, Mr. McClelland? Attorney McClelland, yes, Your Honor. And since it's the first setting, March 20th, 2023, the court is setting an omnibus hearing for January 13th, 2023 at 9 a.m. The omnibus hearing is tethered to those deadlines that were referenced previously, Mr. Allen, and so counsel certainly must be retained before the omnibus hearing to meet those deadlines. And if you cannot retain counsel for financial reasons, notify the court at your earliest opportunity in writing, and you'll be examined to see if you qualify for court-appointed counsel at the court's earliest opportunity. And then they go through the constitutional rights. Asked if you have any questions concerning any rights. He doesn't. Upon finding probable cause, the court set bail at $20 million cash as corporate surety. Bail is permitted. Where the fuck is that transcript? The probable cause hearing. Where is it? And why isn't it in the appellate transcript? I don't know. It should be there. Everything here is kind of strange for me. Why isn't it in there? Oh, sea life vibe. So I'm new to this case. Do you think RA was not involved at all, or involved some and set up to take the fall? There's nothing that has been presented this far that tells me Rick Allen was involved in this. I've gone through his so-called confessions. They don't add up to what we know the crime scene looks like. And I believe that the confessions are false confessions. They are drug-induced, suggested to him by the investigators. It's suggested to him by prison personnel, including but not limited to his prison psychologist, Dr. Walla. Dr. Walla, I believe, is central in getting a confession out of Rick Allen, any type of confession. Dr. Walla no longer works within the prison system. I believe she should be committed into hell. She is a disgrace for her profession. So yeah, I do believe that Rick Allen is factually innocent in this. But I don't have to. I can just throw out the... I mean, I've done a lot of coverage of this case by Officer Holman, Detective Holman. His actions alone should get this case overturned on appeal. So I don't even have to believe he's factually innocent. I only have to point at Detective Holman and say, that fucking retard ruined this case from the very start. That's all I need to do. Him alone, Detective Holman, should overturn this. His actions should have this entire case overturned on appeal. Thank you, Jersey Jan, for gifting a membership. That's very nice of you. Let's continue. To preclude bail, the state has certain burdens to meet, although initially we could set a no bail hold subject to review, I suppose. Does the state wish to be heard regarding the issue of bail or release at this time, Mr. McClelland? Judge, the state is only going to move the court to consider putting a no bail warrant on Mr. Allen, or consider holding Mr. Allen with no bail. Okay, so all of here, I should have just kept reading. Yeah, I should have just kept reading there. I'm orally moving for the court to consider that. The court set bail upon finding probable cause. Yeah, but where is the fucking probable cause hearing? In the case, the defendant was unable to be brought before the court for an initial hearing, and that has occurred. The court is going to order the defendant held without bail pending a formal bail review hearing. But where is the probable cause hearing? This is so stupid. Hi, Kat. Good to have you here. Pending omnibus hearing or further bail review hearing, you're being to be held without bond, and the issue of bond can be brought before the court by written motion by either an attorney of your choosing or court-appointed counsel if you qualify, if you're unable to hire an attorney of your choosing. Do you understand the process? Yeah. Okay, we got a trial from the court. Okay, we got a trial date. We got an omnibus date. If you're unable to hire an attorney, notify the court in writing, and we will have a similar hearing as we had today to see if you qualify for court-appointed counsel. And then, if you do qualify, I imagine we'll address the issue of bail at a formal hearing, but everything is one step at a time in all cases, and even this case. Do you understand that? Yes, sir. All right, anything further today, Mr. McLeland? No, Your Honor. Oh, the court, okay, that will be the order of the court. We got the hearing dates and times. You're ordered to appear as ordered, Mr. Allen. That concludes the initial hearing. That's the entirety of the initial hearing, where Mr. Allen, who was already in jail, now was formally placed without bond in jail. And the second record of proceedings held on November 22nd, 2022. Appearances, Nik McLeland, and here, Rossi and Baldwin has been appointed. Here, before November 22nd, here is the ex parte hearing, or ex parte meeting between McLeland and Diener. Without Mr. Allen, without Mr. Allen's attorney. They decided that Mr. Allen should not be held in a jail. He should be held in a prison. Why is that transcript not in the appeals transcript? We know they had one, because directly after that decision, Judge Diener suddenly retired because of fears. He has never spoken out what those fears actually was, if he was under threats or anything. He just fucked off like a coward. He just fucked off. That ex parte meeting should be in here, and it isn't. That tells me that if the court, under Judge Gall's supervision, the clerk of court decides they don't need this, how can we trust anything in this transcript to accurately describe the trial? So that is my first. Well, I have comments before, but this is the first tangible thing that we know already from Volume 1 or from Volume 2. There will be things missing, because we know that there are things missing. It's insanity. Records of proceedings held on November 22nd for State of Indiana, Nik McClelland. For defendant, Brad Rossi, Andrew Baldwin. Here, Judge Gould has been appointed as a special judge, with Jody as reporter. Jody is the one that there's a lot of people who has been sending in money for exhibits, who are still waiting for it, who have sent. She is the one who said to Criminality that $5,000 and change for the trial transcript, which we fundraised parts of. Well, we did fundraise more than $5,000. But another clerk of court decided to, no, let's publish this with no cost. So, which begs the question, where did Jody, where did all that money go that people sent in for evidence? They sent in cash and thumb drives for specific evidence. Where did that money go, Jody? Did you do a Becky Boo and pocket it? I don't know. Begs the question. Andy called her and she told me it's been returned. Okay, do a FOIA on the actual returns. Do a FOIA on how did you return it. Everybody who has sought the transcripts and the evidence should be recorded. Though that information should be able to be FOIA'd. Appeals are made for walking. Do you think overturning on appeal is possible? Yeah, it should be. With all the shenanigans that went on in this case. But if this is the trial transcript, which we already know in volume 2, things are missing. And the appellate attorneys who are assigned to this case, they are not commenting at all. Yes, the process of appeal is ongoing, as far as I know. I've heard good things about his appellate attorneys, but apparently they do not comment. And that's a choice. All right, let's continue here. Proceedings. The court, we are on the record. Good morning, Attorney McClelland. Good morning, Judge. The court, good morning, ladies and gentlemen. Welcome to Carroll Circuit Court. As Officer Bode has indicated, my name is Frank Gall. I am a judge in Allen Superior Court in our criminal division up in Fort Wayne, Indiana. I'm serving as special judge in the state of Indiana versus Richard Allen. I was appointed on November 3rd of this year by the Indiana Supreme Court by Chief Justice Rush. I will show that the defendant is here in person with his attorney, Mr. Bradley Rossi and Mr. Alec Baldwin. The state is here by the elected prosecutor, Mr. Nicholas McClelland. We are here today on the state's verified request to prohibit public access to a court record that was filed with the court October 28th of 2022. Before we begin, I would just like to inform those of you present here in the courtroom of the courthouse management and decorum order that was entered for this hearing on November 22nd, that I entered with the court on November 18th of 2022. The attorneys received this order, so they know what to expect. And you already, ladies and gentlemen in the gallery, experienced some of the directives. Only one entrance to the building was open. You were searched. Your bags were searched. If you have your cell phone here in the courtroom, again, please ensure that the cell phone is off and no other electronics are permitted in the courtroom. I will tell you, consistent with my practice In Allen Superior Court, if your phone goes off, I will have it confiscated and it will be destroyed. Folks, I've been talking to Indiana-based attorneys and attorneys from other states. That practice has no legal basis. Confiscating, yes. Temporary. The law in Indiana only allows electronic devices to be temporarily confiscated and then return at the end of the day. Judge Gull actually does this. There's been articles about her confiscating phones and tablets and then keeping it for destruction and then destroyed it. And that goes for reporters as well. That is an illegal practice. But why does she do it? Because every time it has been brought up, nobody does anything in the appeals court or Supreme Court. She is allowed to do this, and she will keep doing it because nobody stops her. So what to do if the entirety of the Indiana justice system, despite knowing it is illegal, don't do jack shit about it? What to do? Except talk about it. Except talk about it. Bring it up. Do not stay silent. Do not stay silent. All right, let's continue. Oh, so I see here we are now over 100 people here. And have you all pressed the thumbs up, folks? Have you? If you haven't, please do so. You all know the YouTube things. The more thumbs up, the more comments, the more active chat, the more it gets promoted outwards. So half of you haven't pressed the thumbs up. Folks, come on. Come on. It really isn't that hard. If I can get Megan Fox here to tell you, or you will do it. Yes, I'm threatening you with Megan Fox. Oh. All right, let's continue. She continues with, ladies and gentlemen, please remain seated throughout the proceedings as we go through this hearing this morning. If you must leave, please do so quietly and please do so with the least amount of disruption possible. Once the hearing is concluded, I would ask that you remain seated until the parties and the court has left the courtroom and courtroom security indicates that you may leave. Mr. McClelland, on October 28th of this year, the Carroll Circuit Judge granted your verified request to prohibit public access to a court recorder and order the charging information and the probable cause and other court documents sealed and deemed to be a confidential court recording pending public hearing. That order is scheduled November 22nd at 9 a.m. to be that public hearing. Yeah. I mean, throughout the years, and especially after Rick Allen was arrested, there's been press conferences, there's been articles, everything. But the moment, this is not unusual. Oh, at the beginning of everything, let's have the prosecution story out there, and then boom, seal the records, preferably put a gag order so that the defense can't reply in public. It's not unusual. It is to ensure a fair trial. Fucktards, the only person with the right to a fair trial is the defendant. What the prosecution has is an obligation to conduct a fair trial. They have zero rights. They have only obligations. But if prosecutions around the countries whine hard enough and long enough, there will be a statute. Yeah, they also have a right to a fair trial. No, this pisses me off to no extent. No, they have an obligation to conduct a fair trial. That's it. That order is blah, blah, blah. Under the Indiana Rules of Court, the rules on access to court records were effective January 1st of this year. The burden is on the state of Indiana to demonstrate by clear and convincing evidence that the requirements of Rule 6, Paragraph A, have been satisfied. Since we are proceeding under the Indiana Rules of Court, rules of access to court records are not applicable. The Access to Public Records Act under the Indiana Code requires the state to proceed under the rules of trial rules. So we will be proceeding under that. Therefore, no public testimony or comment is necessary, as that is only required under the Access to Public Records Statutes Title 5. So, gentlemen, are you ready to proceed? Brad Rossi? Yes, ma'am. McClellan? Yes. Court? All right, Mr. McClellan, you may proceed. Thank you, Judge. As the court mentioned, the state did file a verified request to keep the records confidential, and specifically the probable cause affidavit and the charging information. The state's proceeding under Rule 6, and what Rule 6 says, Judge, is in extraordinary circumstances, if the state showed that the public interest will be substantially served by prohibiting access, or the access will create a substantial risk of substantial harm to the state or other persons or the general public, or that a substantial prejudicial effect to ongoing proceedings cannot be avoided without prohibiting access, the court can restrict access to those records. As the court said, the burden is on the state. I must show by clear and convincing evidence that at least one of those requirements are met. Doesn't have to be all of them, Judge, just one. And then if the court does decide to keep the probable cause and charging information confidential, the court's required to do so in the least restrictive means necessary. So, Judge, in that effort, I have decided to present a couple of exhibits for the court to consider. I presented those exhibits to the court, and I want to go over those exhibits, Judge. I presented those to the defense. I have in court today as well. Exhibits, what's been marked as States Exhibits 1 and 2, Judge. Those are affidavits from Exhibit 1 is ISP Detective Jerry Holman. Yeah, Jerry Holman, the living lie detector, who, in my personal opinion, is clinically retarded. Problem is, he is clinically retarded with power. And I will stay. I'll stay with that opinion until proven otherwise. And Exhibit 2 is from Carroll County Prosecuting Officer Investigator Steve Mullin, who also can go fuck himself. They've both been involved in the case for several years. They have intimate knowledge of the details of the case. They both believe in their affidavit that releasing information would jeopardize the ongoing investigation. Hello, Mr. Jingles. Hello. Yeah, of course it would jeopardize the investigation because it would reveal their absolute incompetence, in my opinion. The next exhibit, Judge, it states Exhibit 3. That is a letter from Becky Patty. That is LG's guardians. She's in favor of keeping the records confident as well. And then, Judge, Exhibit 4 is an online petition that circuit not only the county, the state, and the nation. There's over 40,000 signatures on that petition. Also petitioning the court to keep the records confidential. I've never heard of that one, that petition. Never seen it. If anyone has the link to that one, please send it over. Never heard of it, never seen it. The state's moving to admit those 4 exhibits. States Exhibit 1 through 4 offered. Any objection from the defense? No, they didn't object. But in their defense, at that time, they had basically nothing to go on but the states, what they've been handed over initially. Jen the Couch Fairy, was there a petition to vote to keep it open? I don't think so, because nobody knew about the other petition. Not to my knowledge. I've never heard, until this transcript surfaced, I've never heard of it. Until, States, let's see. Jody, I'll have you mark those at States Exhibits 1, 2, 3, and 4 as reflected by Mr. McClellan, please, and show those admitted without objection. It's Exhibit 1 through 4 admitted. Mr. McClellan, thank you, Judge. Judge, there's not a lot of precedent for a hearing like this. I searched high and low for case law, talked to several people, there's just not a lot of precedent. This is an unusual situation, an extraordinary circumstance, if you will. The state is confident in the evidence that's been presented in both the probable cause and the charging information. We're confident of that evidence and of the contents, but I'm concerned. I have two concerns: the continued investigation and then protecting the witnesses involved in that case. Judge, those are my two main concerns. Most of the witnesses were cops. And then alleged eyewitnesses who were at the bridge that day. And if you remember, and we will probably get to that at some point in time while me reading the trial transcripts, nobody got the question, is Rick Allen the person you saw that day? Because the state was afraid of the answer. Judge, those are my two main concerns. It's my job as the prosecutor, in part at least, to enforce the law in an effort to protect the community. It is the public interest for me to enforce that law to protect the community. The first concern talks about the integrity of investigation, and I think that falls under the public interest factor and consideration for the court. This is still a very ongoing investigation. Our goal is to find anyone else who was involved in this heinous crime. Remember when McClellan got the question after the trial? What about the other suspects? And he was absolutely flabbergasted. What other suspect? What? No, never. Never. And here he is on the first hearing in front of Judge Gull, saying, our goal is to find anyone else who was involved in this heinous crime. Because up until trial, actual trial, in the opening statement that Rick Allen did all of this by himself, not a single person thought this was a one-person crime. Not one. That is the public interest, to find anybody else involved and get justice for Abby and Libby. We still get tips every day. Tips come in every day. We have good reason to believe that Richard Allen is not the only person involved in this. That there may be other actors involved. That's why we left the tip line open. That's why we left the tip email open. Oh, you found the petition, Andy. Great. So, it would be interesting to see the names on that petition. 40,000 names. Yeah. I wonder how many of them are related to other suspects or cops. Yeah. They always thought there were more. Nobody thought And I suspect that throughout the trial, McLeland, Holman, Mullen, everybody thought this was a multiple person. But in order to get a jury to convict Rick Allen, they had to go with a one-person crime. Andy, send it to via X. Send it via X. But yeah, everybody thought this was a multiple person crime. And I agree. This was a multiple person crime. Everything on the crime scene and everything surrounding how the girls disappeared kept being disappeared until the day after tells me multiple person crime. The question becomes, at least in the state's mind, is it more important to release the details of the investigation to the public, or more important to keep those confidential in order for the investigation to continue and find anyone else that's responsible? The public has an absolute right to the information. I don't deny that, Judge, but at what cost? This rule was designed for extraordinary circumstances where the court can limit that access. The state believes that this is one of those extraordinary circumstances. Keeping the record confidential serves the public interest. It puts the investigation in the best position possible to determine if anyone else was involved. It is in the best interest of the public that the investigation find anyone else involved. The second part I'm concerned about, Judge, is the safety of witnesses and other people involved in the case. Yeah, because they believed other people was involved. And until they found the other people in this multiple person crime, of course witnesses were at risk. Because these are dangerous people who actually committed the crime. He continues, we have seen the extraordinary lengths the media has gone in order to get the next soundbite or the next clip for their broadcast. You provided them with it. So, but now it doesn't suit you. We are a society of people that has to know right now. Social media, Facebook, Instagram. We want all the information right now, immediately. The media has went to great bounds to interview anybody involved with the case. Mr. Allen's wife, Mr. Allen's old neighbors in Mexico, Indiana. They've staked out his house. Hey, look at that. Andy! Hey, Andy.
Hey, how are you?
I'm doing great. How are you?
Super awesome. I didn't realize that you sent me a link.
All right. Well,
So I did send the link to the change thing. Sorry, don't mean to derail, but there it is. So I'll just sit quietly and add if I can. If not, I'll just go away.
No worries. Thank you. Let's see here. Petition.
It's it started by somebody I don't recognize. It looks like that it was, and I had never heard of it until you just said it now too. So, and also, by the way, who cares what a petition says when it comes to the right for the public to access public trials? I find this pretty unfortunately crazy but standard in this case. And I had no idea this was out there. I wonder if it was taken under consideration. I mean, I'm sure it was, but it was started by somebody in the community, but it looks like it has like 43,000 signatures. I don't know, since it's ended. I've just taken a quick look at it to see if we can see who signed it, but who knows?
Let's see here. Rebecca Lynn Dunaway. I have, let's see here.
Let me just mention something to you quickly. So this person here, I'm just going to mention this or I'm going to leave, but this For Pits person is making claims about my sobriety and I'm not going to have it. So I'm going to go away or
Folks who attack my guests, I don't give warnings. I will yeet anybody at any point in time. So
I will not. I won't stand for it. You can come for a lot of things, but that person right there, get the fuck out of here. Sorry, pardon my French, or
Yeah.
I will leave. I'm happy to leave.
And that person is now yeeted from my channel.
Thank you. Anyway, so sorry about that. Just will not. But anyway, sorry. Proceed, and I'll be quiet now. But hopefully, I can help with there's anything to jump in. So
yeah,
what can I help you with?
This Rebecca, the petition starter, seems to be very involved in getting people to stay quiet.
Yeah, and so this is going to be, I think that this is interesting, and one of the gifts that keeps on giving from my perspective in transcripts are these little nuggets, right? Like now there's a whole other avenue, in my opinion, to look into who was really kind of behind some of this. Who cares? It's just so bizarre that there was a petition that was entered into the record. Anyway, I just nothing shocks me, but yet I remain shocked. So yeah. So I don't know who this person is, and maybe some people do. I don't recognize the name Dunaway, but that doesn't mean anything. But I'm going to be looking into it.
Let's see here. She's also. Let's see here. Where can I find?
I wonder, and my thing is like, I wonder what the impetus was for this. Who, like, was this just something that, interesting. This is very interesting, y'all. And these are public. So that's one thing too, is like, people need to understand these are all public. So it's not like we're outing anybody. Or anything like that. This is all online through change.org. So it's out there.
Let's see here. Dun, 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 petition. Oh, I found her on Facebook.
Yeah, and I think that yeah.
Yeah, I'm not going to show anything.
No,
but it will be interesting to see who is this person and why was she this interested. But that is for later.
Yes. Agree.
All right, where were we? Welcome to my streams. That we might get sidetracked. Nothing unusual. It was media is trying to be interview. Yeah, this is nothing unusual. They went to these extraordinary circumstances. How is it extraordinary circumstances to interview people? That's just journalism.
Yeah. One of the things you pointed out earlier is that they're all about, and I just wanted to get in on your righteous indignation for 1 second, is that the state deserves a fair trial. I would invite the state to go take a long walk off a short cliff.
Yeah. A long walk on a short pier.
Correct.
Yeah. Because it's infuriating because the state has no rights at all. Everything in the Constitution, Bill of Rights, and amendments is about what the government can't do against the people.
Correct. Yeah.
The government has no rights.
Right.
They have only obligations.
And they have an obligation to protect. I was listening to Andrea Burkhart yesterday, I think, talking about this, and then that, at least in the Koberger case, they tried to preclude media and access to documents under the auspices of trying to protect the defendant's rights. Now,
Yeah.
I don't believe that for a second. But here,
No,
Nick and Fran are going on a riff about protecting witnesses and all. They set up this narrative, and it's just to see it and to hear you read it. I'm like, oh God, yeah. It's ridiculous. This is not normal. This is not normal at all.
It should never, but I've seen it in many trials I've covered, that the state always try, but a judge who is a proper gatekeeper says, no, state. Let's hear from the defendant and what he actually said, because you do not represent the defendant. You cannot speak on the defendant's behalf. That's on the defendant. That would be a proper answer.
Yes.
But many prosecutors still say, we do this for the protection of the defendant. No,
not Nick. Yeah, but they're wearing their freak on the outside and not in a good way, you know? I'm just really glad you're doing this because you have such a reach, and there just needs to be more information. So I just want to thank you for that.
Yeah, but also, I mean, everybody who keeps talking about this case helps out in the reach of this. So yeah, I have a little more subscribers and stuff, and I get it a little bit more reach. But I also noticed with this, the more the smaller accounts that keeps talking about this, the higher the chance of a bigger one also doing it. Now we already have Andrea.
Yes.
And so that is a huge bonus. But we have these other content creators with 500,000 up to 1 million, because they will see what trends, and then they will cover it. So if we small accounts make this somewhat trending, the higher the chance of other people picking up on it too with bigger accounts.
Well, and I think that the big thing that and then I'm going to jump off, and because I don't want to derail you anymore. But one of the things I wanted to say is that, you know, I come at this from what can I do with my experience to bring my background in journalism is to approach people like Andrew Baldwin and say, look, man, you can. I mean, I'm nobody on the interwebs, but you know, I do actually have 20 years experience and a pretty good track record if anybody wants to give me a bing. So that's how I get people to talk to me, because I've been doing this for a long time. So hopefully, and I don't care about likes or any of those things. Take whatever Baldwin said, use it, and if people can use it and pull something out, it's the first in one of what I hope are many conversations, and getting him to release information. So that's my big goal. And so
and I'm probably going to be criticizing, but it's easy to criticize as
I'm criticizing
after the fact. But also it was very relieving to see that he also has self-criticism, what he should have done. We've seen each other on X commenting on, oh no, they stipulated, oh, that's the worst move in probably in that entire trial, was to stipulate on the evidence.
Well, and I push, and you know, I pushed back on him. I'm like, look, man, why didn't you get him out of there the minute you got on the trial? And he was like, yeah, we probably should have, but we just proceeded. We were acting like this was a normal case. And so pushing back, because there are plenty of places to do that. And he seems, even if he's not open to it, doesn't matter, right? That's my job is to ask him those questions. And you know, he answered it like, yep, we should have. But anyway, so that was my point. So I don't give a shite about any of this online whatever, but do if you want, take any and all of it, you know, if it's useful. And I would advocate for you folks to reach out to him too, that have these spaces. So That's it. And my hair's on fire, but I just wanted to jump on, say I got that petition, and now I'm going to go back to drinking just buttloads of coffee. And so thank you. Thanks. I didn't realize you sent me a link. So now I'll
no
leave it
worries.
alone.
Good to have you here. Good to have you
here. Okay, so we should talk again.
Yeah, we should. We should. Yeah.
Okay. Smell you later. Hate you guys. Hate you guys.
See ya. All right. Dun, dun, dun. Let's continue here. Even by Rick Allen's own admissions, a letter to the court asking for a public defender, they forced his wife to move and abandon their home. They are talking about the media. We also know the prior judge, Judge Diener, recused himself by his own admissions to an email to the court's judicial staff. He had concerns for his safety, for his staff, due to the facts surrounding their arrest. So much to the point that he felt it was necessary to get out of the case, Judge. Yeah, but he never actually stated what it was. Why? He never did. And that is infuriating. Absolutely infuriating. When a judge recuses himself out of fear, he should be able to list each and every reason. And he didn't. Simply because I believe he's just a coward. He might have seen, this might have people look at me and every ruling I do. And I bet he knew that ex parte meeting, if he kept being on the case, would come back to haunt him. But now he's retired and cannot damage any other case. So fuck you, Judge Diener. Fuck you all the way to hell. And so the state believes these are real concerns for the witnesses and the people involved in this case. Look at the amount of security we have here today, Judge. We don't have a lot of security in Carroll County, but I can tell you, my tenure here, I've never seen the display of law enforcement that we have here today. They are there because you told them to be there, you fucktwat. This is a highly publicized case. We have had countless meetings over the couple of months or past month about security, how to get Mr. Allen in here, all for the safety of everybody involved in this case. Why the fuck are those transcripts not a part of the appeals transcript? Every single word regarding Mr. Allen, his security, safety, how he's transported, every single word should be in the appellate transcript. And it is not. Why? It's infuriating. Blah, blah, blah. Judge and should extend to the witnesses and should extend to the other people involved in this case. The court can imagine the media pressure, intimidation, and evidentiary issues that may arise if the name of the witnesses are released and those witnesses are subject to constant harassment and bombardment by the media. At this point, they thought that this was a group of people committing the crime and that people were out and large. So, yeah, I can understand it. But with the facts at hand that we have now, fuck you, Mr. McLeland. The state also has concern that they may be interviewed on the 6 o'clock news and the testimony will be taken as such. That causes evidentiary issues. Some of the witnesses were juveniles at the time. They are now 19 and 20 in their first and second year of college. They need to be able to focus on what they're doing in school and not to be worried about the constant harassment from media. And I remind you, Judge, some of the witnesses are still juveniles, and so there's concern there. Yeah, we know, Mr. McLeland, especially that person. When you remember, Rick Allen saw a group of 3 girls. McLeland told the court and everybody involved that a group of girls seeing bridge guy, group of 3. when they were actually a group of 4, but the 4th one was a bit younger. And he only did that to make it seem like it was the same group of girls. It was never the same group of girls. Never. You cunt. Again, Judge, the burden is on me. I have to show by clear and convincing evidence, and so the gauge starts at the presumption that the information should be released, and I have to convince you to move the ticker far enough to keep it confidential. And so, Judge, I looked up clear and convincing. We don't deal with it a lot. We deal with beyond a reasonable doubt. And so I looked up the jury instruction for clear and convincing. That is civil court, by the way. Jury instructions say the facts supporting the claims are highly probable. Look at what we hear here today, Judge. The chaos, the amount of attention this has drawn, the concern for safety, defense counsel, the state, everybody has a concern for safety for themselves, for Mr. Allen, for everybody involved. Went to extraordinary lengths to protect everyone here today. We can't look at this case like any other case. This is an extraordinary case. It is by its nature. The state believes it's important and allowed under Rule 6 to keep the PC and the charging information confidential. All you had to do was to black out the names. But you wanted everything confidential because it would have shown early on the absolute... It's so bad. The affidavits and the charging documents, it's so bad. In my opinion, what they claim was enough for probable cause, it's not even close. It's not even close. The state believes it's important and allowed under Rule 6 to keep the PC, blah, blah, blah. Yeah. So the state respectfully would ask the court to continue to keep the PC and the charging information confidential. However, if the court deemed that those items should be released, the probable cause and the charging information, I would ask the court to consider redacting. He actually asked for it. I should have just kept reading. I would ask the court to consider redacting the witness's name to protect their identity and the people involved in the case. In an effort to do so, Judge, I have a redacted charging information and probable cause that I'd like to submit to the court for their consideration. It has names of the witnesses and the people involved in their case redacted. And if the court so inclined at this time, I'd like to at least admit to that to the court, not as an exhibit, but as for consideration for the court to consider a redacted version, as opposed to releasing the entire document. The court, any objection, gentlemen? Rossi says no, ma'am. Okay, thank you. I want to mark this as an exhibit. This will be my work product, so it's not available to anybody other than myself and my staff. Mr. McClelland. Thank you, Judge. So, Judge, I'm about done. I wanted to leave you with one last thing. As I said, I did a lot of case law research to find any support of my motion or anything that is not in support of my motion. I came across a case, Brown versus State, Indiana Supreme Court case. It's from 1969. It's old, but I wanted to read you a quote from the case because it's kind of hit home dealing with the circumstances that we have today. And the court says this, quote, the right of the news media to fairly and accurately report the news, the right of the defendant to a fair trial before an impartial tribunal, free of influence of generated prejudice and inflamed passion of the community, and the right of citizens to fully comprehend and analyze the administration of the court system are elements necessary to the attainment of justice. Elements necessarily to the attainment of justice. If any one of these rights fall, the rest will surely fall, and the term justice will become hollow and meaningless in our constitutional system. Okay. Yet again, the state's asking you to keep those things sealed. I appreciate the time here in court today, and I appreciate you allowing the state to have entered its exhibits and make an argument. Thank you, Judge. Thank you, Mr. McClelland. Mr. Rossi. Thank you, Nick. Judge, let me just start by saying that Mr. Allen, in this case, seeks transparency. It seems to me that, in the normal course of operation in our courtrooms around the state, that's what we get. That's the norm. And really, there's no reason in this case to sway from that. I would point out first, if I could direct the court to the pleading that was filed on October 28th, 2022. the verified request to prohibit public access to a court record, this pleading, if you look at it, is deficient on its face. And I would direct the court specifically to the fact that Rule 6a specifically says, quote, a verified written request to prohibit public access to a court record may be made by any person affected by the release of the court record. It requires a verification. And the verification in our business is that word is a term of art, as you know. IC 1145 codifies the very essence of what a verification is. And what you're going to find, and I would direct the court to Smith versus King. This case is a 1999 case involving an election dispute. Specifically, Headnote 3 of that case addresses what a verification is and what the minimum standard to meet that verification is. And it says, quote, when applied to pleadings, verified means supported by oath or affirming in writing. Pursuant to Trial Rule 11b, it's sufficient if the petitioner simply affirms the truth of the matter to be verified by affirmation or representation in substantially the following language. And it says, quote, we affirm under the penalties for perjury that the foregoing representations is or are true, end quote. The essential purpose of a verification is that the statement be made under penalty of perjury. And it cites Austin v. Sanders, 1986. This document contains no verification which references that has been signed under the pains and penalty of perjury. So I think it's facially deficient, and I would ask the court to consider that before we even get to the rest of this. And of course, I can offer up the case to the court, but I know you have the citation, so we should be good. Moving on, we get to the Access to Public Records statute, this statute, open door law, all those kinds of phrases that get thrown around in our practice. And what I would say to you is that, when I took a look at this statute, I was actually surprised to find that the very first section, 514.3.1, the first chapter codifies public policy, and I think that's extremely rare in our practice when you actually see a statute that essentially codifies the public policy. And I'm not going to read the whole thing, Your Honor. You probably already looked at it, but the first sentence says, quote, a fundamental philosophy of the American constitutional form of representative government is that government is the servant of the people and not their master. It sounds like something Thomas Jefferson wrote, frankly, but more importantly, you get the last sentence and it says, quote, this chapter shall be liberally construed to implement this policy and place the burden of proof for the non-disclosure of a public record on the public agency that would deny access to the record and not on the person seeking to inspect. It says two important things. One, liberal construction, which means it pertains to many documents in our judicial system. And two, most importantly, it places the burden of proof on the state in this case, which Mr. McClellan has already acknowledged. And that burden of proof is, of course, the clear and convincing standard. So I think the point I'm trying to make here is that the legislature felt so strongly about the disclosure of public records that it actually codified the public policy. I just think that's really unique. And one of my counterparts that I practice, which would say, quote unquote, that's pretty cool. It's just not the kind of law that we're used to seeing. So moving on, this Rule 5 is kind of the driving force here, actually, in this access to court records arena that we're in. And Rule 5 basically says that, exclusion upfront is, the transparency upfront is where the court ought to be with this, and only extraordinary circumstances should the court deviate from that. And that word, extraordinary, is the second word in Rule 6.2, by the way. And what you see, if you read through these rules, is that there are a lot of terms that are used to just really bolster and beef up that burden of proof. And I think they just speak to how important it is that we have transparency in this community, in this system, I should say. And that's no different in this case. So let's get to Rule 6. Mr. McClellan hit on a couple of the bullet points. One being that the public interest is substantially served by prohibiting access. Again, another strong word, substantially. Disclosure of the records will create a significant risk. Again, a significant risk of substantial harm to the prosecutor, other persons, or the public, disclosure will work some prejudicial effect on the ongoing proceedings. So all strong words, again, consistent with the clear and convincing standard. Let's touch on the first one specifically. Will the public interest be substantially served by limiting access? And Mr. Allen's position is no, it will not. It's exactly the opposite. This is a case where the crime occurred over 5 years ago. It's taken almost 6 years for an arrest to be made. Time and public resources have been exhausted over that scope of time. Those are almost impossible to quantify. And any secrecy involved in this investigation, in my opinion, and Mr. Allen's opinion, has done nothing but increase the hype and the public interest. I mean, it's the idea that the public has known very little is what has caused, all this attention to occur. And so, by continuing that pattern or allowing the state to maintain this confidentiality, I think we're just this word, the problem, enhancing the problem. My suggestion is that the opposite would happen if you unseal the records, and that is to say that the public can see the truth regarding the facts. That supports the allegation. In this case, they can see where the expenditure of their tax dollars has gone. And Mr. McClellan talks about the second prong here, and that the release of the records would create a significant risk of substantial harm to the prosecutor, other persons, or the public. At this point, I don't want to sound flippant, but what's the risk? I mean, we all just walked in here today, with security and the right safeguards in place, and we're fine. There are a few human rights referenced in the affidavit, and I do understand that they may play a little bit larger role in the court's opinion today, just trying to protect those individuals. And, frankly, Mr. Allen, the defense doesn't have any problem with redacting some names of witnesses and things of that nature that might serve a purpose. But, I haven't heard, or nor have I seen in any of these exhibits that were introduced by the state, any actual references or appreciable threats that have occurred. Thank you, Lark. Perpetuating. Thank you. I like my audience. I like my audience. You do good. You do good. In appreciable threats that have occurred. In other words, we didn't John Doe or Jane Doe come in here today and tell you that they have received a phone call from an anonymous person last week with a threat on their life. I haven't heard an officer say that he or she their lives have been threatened. I think a lot of this is just driven by the social media aspect of this. You can get on Facebook any day of the week and find somebody threatening somebody. Not that I don't take those things seriously, but it's like fast food. Most of that doesn't have a lot of quality to it. It's just quantity. And I haven't heard any evidence today, other than some argument about the law, which actually supports the idea that there are any appreciable threats on anybody involved in this case. And so, any suggestion at this point regarding the second prong that there will be some significant harm to the public or people involved, I think is just conjecture and speculation. Moving on, there's a practical problem here too. And the practical problem is if the court orders these records to remain confidential, we're going to be forced to walk into this courtroom and delicately dance around all the factual scenarios in this case because the public's going to be sitting behind us. And that doesn't seem to make any sense. It seems to make things more difficult. Yeah, I think that's the actual goal here. You're going to have people reading between the lines. All this stuff's going to go down in print, and then you're going to have all these, the public trying to decipher what we did and didn't say, and what we're inferring, and it makes our job way more difficult. I would argue that it's going to make Mr. McClellan's job more difficult. Yeah, I know. Classic overthinker. Rick was threatened daily. And they didn't care one bit about that. We got a bond motion pending. How do we talk about law and facts in the suppression hearing? How do we talk about law and facts in the hearing of change of venue? All those things which are pretty customary in cases like this. The public will be sitting right here the whole time, and so it just doesn't make any sense practically either. And I'll just finish with this. The burden again. We talked about the clear and convincing evidence. I haven't gone back and counted. I didn't, do any internet searches before I came in here today. But over the last 5 years, I had some very integrated memories of state police press conferences in this community. Yeah. I don't know if there were 2 or 4 or 6 or 8 or 10. I frankly don't know. It seemed like a lot. And, in my mind, for the state to come and for the state to be a part of that process of having public press conferences, releasing composites, things of that nature, and asking the public for help, and then turn around today and suggest to the public, we don't really want you to see what's here. It's kind of like talking out of both sides of your mouth. I mean, that's the way I view it, and I think that's the way Mr. Allen views it. And, we think that the standard is extremely high here, clear and convincing evidence. Nick gave me a little crash course on what the Black Law Dictionary says. What I know about clear and convincing evidence is, for those of us that practice in civil court from time to time, it's the standard that we employ when we are trying to terminate somebody's parental rights, which I think is pretty darn high. And to say that the state has met that burden in this case, I think is just not accurate. None of these documents that you've seen has any information in them which suggest anything with detail that somebody's in harm's way or that some other suspect is, out there and needs to be apprehended. It's just conjecture, and we would ask that you unseal the records, if you will, for the lack of better phrase, and let's move on with this. Thank you. And a response, Mr. McLeland. Mr. McLeland, no, Your Honor. The court says, well, gentlemen, I really appreciate your excellent oral advocacy. I will take the petition under advisement to review the exhibits that have been submitted, the case law that has been argued by counsel, and issue a written ruling in due haste. I know that this case has generated a lot of public interest, and I know that the attorneys and Mr. Allen deserve this court's attention as quickly as possible. I know with the holidays coming up, that will not interfere with my ability to review my notes and the exhibits and issue a written ruling. Mr. Rossi, you and Mr. Baldwin did file a motion or a petition to let to bail. Can we set that for hearing while we are all here today? Mr. Rossi, yes, ma'am. The court, so that we can get that matter resolved. Are you looking at this year as well, or Mr. Rossi? I'm thinking January. Is that the court? You're thinking January, Mr. Rossi? Yeah. Mr. McLeland, yeah, that's fine, Judge. I'm out the first week in December, and then we have a jury trial starting here December 12th. So December is kind of the court, okay. Mr. McLeland, shot from the state's perspective, Judge. So I'd be looking at January as well. The court, okay. Mr. Rossi, I think my biggest concern is just frankly giving Mr. McLeland's office some time for him to gather some of the basic discovery and us being able to have a little time to sort through it. The court, I was going to ask you about that. Mr. Rossi, yeah. The court, I know that the prosecutors indicated it's pretty much an open file discovery policy here in Carroll County. Oh, no, it's not. Oh, no, it's not. It's not. Mr. McLeland answers, it is, Judge. Yes. You fucking liar, Mr. McLeland. You did everything to hide things from the defense. You tried to hide the other suspects. You tried to hide other suspects that had confessed. You tried to hide everything about the Odinist theory. You tried to hide everything that pointed to other people than Rick Allen. So this, you lying sack of lies. Ms. McLeland, it is, Judge, yes. The court, you received what? Anything? Mr. Rossi, well, just a PC affidavit. The court, okay, so you don't have any of the formal discovery from the state of Indiana. Mr. Rossi, yeah, I don't know what the volume's going to be like, so I don't want to get ahead of ourselves on the scheduling issue. I wouldn't even have a problem in the early February even, if that's reasonable, or am I? Attorney Alec Andrew Baldwin, no. Mr. Rossi, late January, early February. Mr. Baldwin says, I would like some time to the court. Are there any particular days of the week that work better? I'm looking at the first week in February then, if that's what you all are talking about. This is my calendar for the next 2 months. So just so you know, Indiana also have the equivalent. It is basically a Rule 14. The moment Rick Allen was charged, it's an automatic discovery. Hand it the fuck over. There are obligations automatically once Rick Allen gets charged. Every affidavit, every probable cause affidavit, every search warrant, everything. Boom, here it is. Should have been handed over at this hearing, even before this hearing, to attorneys Rossi and Baldwin. And to my understanding, not all was, I mean, it's insanity, the amount of information they still have. And in my opinion, at this point in time, they already knew the first 70 days was gone. They knew. So this is just theater from the prosecution. Mr. Baldwin, Judge, I will be in a murder trial down in southern Indiana first week of February, so that would not work for me. The court, so that won't work for you. Okay, how about the second week? I'm in a murder trial every week, just so you know. Mr. Baldwin, yeah, let's see here. The court, so the second week in February. Mr. Rossi, I'm more open than it sounds like than the court. Second week of February is fine with me. Mr. Baldwin, not knowing how long that trial is going to last, if we're going to do the second week, I prefer like the 10th. It should be completed by then. I hate to continue it. The court, okay, I was looking, so you're looking at the first full week, the 10th. Mr. Rossi, Friday, you're saying the 10th. Mr. Baldwin, right. The court, I don't want to jam you up. I mean, if that's not a good day, we can go to the week beginning February 14th. Mr. Baldwin, I'd actually prefer that because I'd like to come out of that trial and have time to prepare for. The court, okay. Mr. Baldwin, the hearing. I appreciate it. Of course, I also have another murder trial scheduled that week, but I don't think that's going to go. So what about February 17th? Will it take all day? Is that fair? Half a day? Mr. Rossi, I think we should set the day aside. The day? The court? Mr. Rossi, just to be until we get off and running here and we have a better idea of kind of how quick the lawyers work and that type of stuff. The court, okay. I'm okay with the 17th. Nick, Mr. McClellan, that's fine. Mr. Baldwin, yes. The court, all right. February 17th, can we start at like 10? That way my staff and I don't have to get up that early. My intent is to have that as many hearings here in Carroll Circuit as possible. I have no idea what the calendar looks like for the sitting judge. Folks, this is before. Now, at this point in time, Mr. Allen is in solitary in prison. And Mr. Rossi and Mr. Baldwin still, at this point in time, they still don't know how limited they would be in meeting with Rick. They, at this point in time, didn't know that the guards would film them in their meetings with Rick. They didn't know his guards, Rick's guards, would be people with Odinist patches. They didn't know at this time, and probably had no idea what they were in for. For them, this was just a normal trial. Everything should get smooth. Everything should be handed over with no issues. They had no idea at this point in time what was going to happen later. No idea. She continues, I have no idea what the kennel looks like for the sitting judge. Mr. Rossi, sure. Mr. McClelland, we don't have anything on that date as of now, Judge. The court, okay, as of now. Mr. McLeland, I have the court calendar. Now that obviously is subject to change, but right now there's nothing set for that day. The court, okay, so we could set it February 17th, 2023 at 10 a.m. And I'll make sure that Mr. Allen joins us. I'll get a transport order. All right. I know that we have an Omni hearing in January. There's already been a trial setting, and it was my understanding when I spoke with the judge before, after his recusal, that the trial setting is a first setting. Mr. McLeland, that's correct, Judge. Jadzia, they know there was nothing normal about this trial. Yeah. At this point in time, Rick Allen had just been transferred to a prison cell where the guards, the inmates, the prison psychologist, the investigators, and the judge all cooperated, knowingly or unknowingly, in breaking Rick down. And he broke. The court which, Mr. McLeland, when the prior, sorry to interrupt the court, when the prior judge said it, he did said it as at the first setting in March. The court, okay. Mr. Rossi, I'd say we just let it sit for now till the court sit. Mr. Rossi, yeah, I mean, we're not setting aside that week yet, right? We just have the date on the calendar. Mr. McLeland, so do we need to change the omnibus date to the let bond date hearing date? The court, I'm happy to do that if you'd like. Would that be easier for you, Mr. McLeland? I think that makes sense, but Mr. Rossi, I think it's a good idea. The court, okay, so cancel January 13th and we'll just do February 17th as a bond hearing and an omnibus hearing. And that's satisfactory to counsel, Mr. Rossi? Mr. Rossi, yes, ma'am. The court, okay, is there anything else that we need to do on the record, Mr. McLeland? Mr. McLeland, I don't know. I don't believe so, Judge. No. Mr. Rossi, nope. The court, Mr. Rossi? Mr. Rossi, no. The court, all right. Thank you, gentlemen. Mr. Rossi, thank you. The court, I appreciate your advocacy. Mr. McLeland, thank you, Judge. The court, ladies and gentlemen, as I indicated, if you would all remain seated until the parties and Mr. Allen had been removed from the courtroom. And this concludes the proceedings had on November 22nd, 2022 in Indiana, this cause. Yeah, as I said in the beginning of the stream, the reading of the individual hearings will be cut out to separate videos and will be named as that specific hearing. So it will be easier than to just, here's part 1, here's part 2, here's part 3 of the streams, which might be a number of hours long. So I will cut out every part of this, every hearing and stuff. I will cut out the discussion I had with Andy to a separate video and stuff like that. Just to make it easier for people, for you viewers, to when you're referencing something to someone, here it is. And it will be easier for me to also go back if in a later stream, hey, Nick, remember this? No, I can also go back. Hey. Go back to the top of the name. Oh. Yeah, this is... Let's go back to the top. Yeah. This is the one we've been reading so far. Records of proceeding held on November 22nd, 2022. Which page? Damn it, what page? All right, what is next then? Record of proceedings at hearing held January 13th. I thought they were going to cancel that, but apparently not. Oh, hold on. Let me do a swoop. Where's my swoop? Yes, folks, that is my swoop. It helps me find where, when I cut this up to the video. Oh, there it is. And that, folks, is my Norwegian fire-farting dragon. You can sneak up on that one from behind. All right. And thank you, everybody, for being here. Thank you. Hit that thumbs up, by the way. Let's see. Last time I tried to remind you people, only half of you had hit the... Let's see here. Yeah, we currently are at 130 likes, which is great, because that is roughly how many who is here right now. But I also see that we have a grand total of 415 unique views so far, which means you're a bit behind. You're a bit behind. And thank you, thank you, Liz Bird, for your £5 super chat. Thank you. Finally caught up on quite a few others after Karen Reed and my hauls, so now I can dedicate my time to catching up on Delphi and Lego. Yay! Thank you so much. Thank you so much. That is so sweet. And folks, I say this: supers are never necessary, always appreciated. And I will say you this: if you are struggling, I specifically ban you from supporting this channel financially. If you are choosing between, hey, let's send Nik a super or bread, choose bread. If you have to think about it, oh, I want to, but should I? Don't. Just don't. If you want to support financially and you don't have the means, go watch my videos. There's ads in them. That way, yeah, I get the views up and stuff like that. But if you don't have the means, do not dare to send me supers. All right, let's continue. Hi, Bridget. No, I will not go over the Walsh documents. This entire stream is about the Delphi. I will go. I have to get to the Walsh documents in a separate stream or video. But thank you for being here. All right, January 13th. McLeland, Rossi, Baldwin, Jot Gould, and here's Jody, the reporter. Proceedings. The court. Well, good morning, everyone. We are here on State of Indiana versus Richard Allen. I'll show the defendants here in person with counsel, Mr. Rossi and Mr. Baldwin. The state is here by the elected prosecutor, Mr. McLeland. We are here originally. We set this hearing on the defense motion for a change of venue. I would just remind everyone that the court has again issued a management and decorum order for this hearing. At the conclusion of the public portion of the hearing, ladies and gentlemen, I will clear the courtroom. There is an ex parte matter that we need to attend to with myself and counsel for the defense. This is, by the way, how you should announce an ex parte meeting. Announce it in open court. Not what Judge Diener did with when he decided to put Rick in prison instead of jail. You announce it. You make sure that everybody knows. So in that regard, Judge Gall is better than Judge Diener, because Judge Diener, go fuck yourself and burn in hell, you coward, had an ex parte meeting with only the prosecution, where they decided that Rick Allen should be protected in prison instead of jail. And they did that without Rick Allen even knowing about it, and Rick Allen's then counsel being notified, despite McLeland and Diener knowing that he had an attorney. So again, Judge Diener, unless you publicly apologize for your part in this, you're going to burn in hell for what you did to Rick Allen. All right. The defendant will remain. The prosecutor and all of you will be asked to leave the courtroom. I think my security detail, which is Officer Bode and Tinkle, that's an unfortunate name, will remain in the courtroom. I believe the gentleman that have escorted Mr. Allen into the courtroom will also remain in the courtroom. At the conclusion of this hearing, then, we'll take up the ex parte motion. Since the scheduling of the hearing on the motion for change of venue, I have added on my motion the state's motion to prohibit parties from disseminating information that was filed by Mr. McLeland on November 22nd of last year. Additionally, then, I set the supplemental motion for discovery that was filed by the defendant on December 30th of last year, and the state's response to that motion, which was filed on January 12th, the day before this hearing. Yeah, the games have begun. So we need to take care of those things. I appreciate those of you in the audience. I appreciate your patience. I know the hearing was scheduled for 10 o'clock. I met with counsel in chambers to discuss procedural issues and to figure out where we're at with everything. So I did grant the state's motion. I know we keep calling it a gag order. It's the motion to prohibit folks from discussing things. Yeah, that's the gag order. The prosecution, up until that point, numerous press conferences, interviews, articles, all the fucking things. But the moment Rick Allen was imprisoned, so the gag order was for Rick Allen not being able to defend himself in public. The court of public opinion should not be swayed from the prosecution's narrative. We had the opportunity to discuss in chambers the professional responsibility of counsel, the requirements that they are permitted under the rules of professional responsibility, to discuss procedural matters, potentially to discuss the upcoming bail hearing that's currently scheduled for February 17th. And that is basically the extent of what the attorneys are permitted to discuss with members of the media or the public. I would remind those of you that are in the courtroom that are family members and potential witnesses in this matter, you are also covered by the gag order. And I would ask that you respect the gag order and not discuss with the media the facts of the case, your testimony. Anything that would be inappropriate for the attorneys to discuss would also be inappropriate for you to discuss. And I appreciate your continued honoring of that order. Is there anything else on the gag order that we need to discuss on the record, Mr. McLeland? McLeland? No. The court? Gentleman for the defense? Rossi? No, ma'am. So my recitation of our discussion adequately has been reflected on this record. Mr. McLeland? Yes, Your Honor. The court? Thank you. Attorney Baldwin? Yes. At this point in time, I wish that Attorney Bradley would have put on the record that we have our objection towards this. But he still thought this would be a normal trial. The court. I know that discovery in this case is more than voluminous. It's extraordinarily voluminous. And I know that the state has an open file policy basically, where you give everything to the defense. Keeping up the lies. I appreciate that. I'm sure the defense appreciates that, but I know as well there are just thousands of pages of discovery. What I would like to do, gentlemen, is I know that you've been working very diligently with each other to discover information back and forth. Mr. McLeland, you provided so far everything that you have. No. We know that's bullshit. We know that is an absolute bullshit. Continues. I know that the defense has the opportunity then to recategorize it as you see fit for your purposes. So rather than rule or do anything on the supplemental motion for discovery that was filed by the defense and the state's response thereto, I would like to take that under advisement to give counsel the opportunity to work as diligently as you have been working. I've shared with you some of my thoughts about the discovery, and again, I appreciate that the state has been very diligent in providing information to the defendant. And I trust when the defendant acquires information, it will be as diligent in providing that to the state. Is that an accurate statement, Mr. Rossi? And Mr. Baldwin? Yes, ma'am. Yes. So is there anything further we need to discuss about discovery, or does that reflect what we discussed in chambers? Mr. McLeland, in the state's perspective, that reflects what we discussed in chambers, Judge. Thank you. Mr. Rossi and Mr. Baldwin? Agreed and yes. The court. Okay, very good. All right. Then we have the motion for change of venue that was filed by the defense. Thank you for the good advocacy on behalf of Mr. Allen, Mr. Rossi, and Mr. Baldwin. I think it's patently clear from the filing that you provided to the court that it would be difficult, if not impossible, to find a jury here in Carroll County, Indiana, that would be not involved in some fashion with the underlying investigation or the facts of the case. Mr. McLeland, it's my understanding that you agree with that it would be difficult, if not impossible, to find a jury here in Carroll County. Correct, Your Honor. I believe that's accurate. Okay. The statute, however, gives the court the opportunity, rather than completely venue it to a completely different county, that the statute gives the court the opportunity to recognize that we cannot, in fact, select a jury in Carroll County from Carroll County citizens, but that we could go to another county and select a jury and bring them back to Carroll County, so that the trial could be conducted here in Carroll County. Is that fair? Mr. McLeland, Judge, that is fair. I believe that is the case. The court, okay, Mr. Rossi? Agreed. Okay, I think it's really important that we try this case here in Carroll County. I think all of the witnesses are here. The families of both the victims, as well as Mr. Allen, friends, are all here. I think the expense to witnesses for both the defense and the state would be extraordinarily if we were to take this case outside of this county. So my preference would be to acknowledge that we cannot get a fair jury here in Carroll County, but rather go to another county and select a jury from another county and bring them to Carroll County. I have my financial coordinator here with me, as well as my court executive and director of court operation. They've been looking at other potential areas that we could select a jury from. I know we had some brief discussion in chambers about some particular counties that we might go to. I know that you had the opportunity, Mr. Rossi and Mr. Baldwin, to speak with Mr. Allen about that. And what I would like to do is ask counsel to notify the court within a week off from today's date, if you have agreed upon a county that we can go to select a jury. So I would accept an email from the gentleman that you have agreed upon a county, and then I can contact whatever county you have agreed upon to see if they are able to accommodate us. Is that acceptable to the defense? Mr. Rossi says yes. Mr. McLeland says yes. And again, it's important for the state's perspective to try the case here, and I'll work diligently with defense to attempt to find a different county to pick the venue from, Judge. The court, okay, all right. I think other than the ex parte, is there anything else that we need to discuss on the record, Mr. McLeland? Mr. McLeland, I just want to confirm the February 13th date is for the let bail hearing, and from the state's perspective, I don't know of any other motion to date that we need to discuss on that day, and I want to confirm that with the court. The court, actually, it's February 17th. 17th, sorry, today is the 13th. February 17th, yes, Judge. At 10 o'clock. Yes, okay, 10 o'clock, and that will be here. That's also our omnibus date. Mr. McLeland, okay, right, okay. The court, I know that we have a trial scheduled in March that was scheduled at the initial hearing back in October. I can't see that happening. I mean, you're both looking at me like, there's no way, not going to happen in October. Mr. Rossi, I think we can just have an agreement that, an understanding that we'll address that at the bail hearing. The court at the bail hearing? Mr. Rossi, yes, I think we're all on the same page about Mr. McLeland. I'm satisfied with that, Judge. Mr. Rossi, realistic. Mr. McLeland, I don't anticipate it happening in March. I think that's ambitious, but we can address at the omnibus hearing, Judge. That's fine. Ambitious, that is a good way to put it. Okay, so nothing then else from the state. Mr. McLeland, no, Your Honor. The court, Mr. Rossi. Mr. Rossi, no, ma'am. The court, okay then. The bond hearing, the omni, and the discussion about the feasibility of the trial that will happen Friday, February 17th at 10 a.m. here in Carroll Circuit Court. I will get a transport order to make sure that Mr. Allen is brought back to us from his current incarceration. Is there anything else we need to chat about, gentlemen? No, Your Honor. Mr. Rossi, no. The court, no. All right, thank you very much. We will then proceed into the ex parte. And I know that the gentleman ringing the courtroom from the law enforcement will escort all of you out of the courtroom, including the state of Indiana. Mr. McClelland, thanks, Judge. The court, thank you. This concludes the proceedings had at the hearing held January 13th, 2023 in this cause. Nothing about this particular hearing is strange. It's just that after the fact, we know that when they say that the state has an open file policy on discovery, we know that Mr. McClelland was lying. I mean, it's not even in contention. It's not even funny. The way Mr. McClelland effortlessly lies to the court. So while I'm reading, I'm missing out on a bunch of things in the chat. So if you have a question, put a big red question mark in the beginning or end of it. If I don't see it, write it again. Write it again. And hello, low light recovery over a drum roll. Yes, I'm covering this over a drum roll as well. This is not on X, because I've discovered that if I stream on X and YouTube at the same time, somehow it takes away views from YouTube. Don't know why, but that's just the fact of it. And I will still post clips on X to get people to watch the stream or the videos here on YouTube. All right, let's see. Do we get to the ex parte? Yeah. Record of proceedings at ex parte, hearing held January 13th, 2023. This is what should have happened with Judge Diener's ex parte meeting with the prosecution and investigators. There should be included in all of this that, but it isn't, which tells me and should tell you all that everything won't be here. It simply won't. Because if they hide that, what else will they hide from the appeals attorneys? Oh, thank you, Kim. Nick, why are you so awesome? I can take credit. My dad taught me well. Bridget, curious if other Judge Gull cases were this bad. I assume Judge Gull is the kind of judge that if she believes you're innocent, she will make sure you get an accused get the trial that might even acquit them. If she believes you're guilty, she will not care what about law, constitution, anything to get a conviction out of it. Nicola Koch, can the appeal judges request the missing dogs? The appeals attorneys can request it. I assume they will be aware of it. Faye Dunaway, yes, that's the name of an actress. Yeah. But you're talking about the petition starter, Rebecca Dunaway. I don't know if she's local or not, but I will look into it more after this stream. All right, let's continue with the ex parte. Appearances, McClelland and Rossi, Baldwin. Judge reporter. Well, Mr. McClelland, it's an ex parte hearing. It should have, Mr. McClelland should not be in there, but okay. Proceeding the court. All right, the officers that are here in the courtroom, gentlemen, would you stand? And the two gentlemen in the back of the courtroom, can you hear me okay? An identified officer? Yes, ma'am. The court, okay. And the officers with the Allen County Sheriff's Department, would you all please raise your right hand to take an oath? Do you and each of you solemnly swear or affirm under the penalties of perjury that you will not communicate in any form or fashion to anyone the contents of this ex parte hearing, so help you God? Bailiff sworn. The court. Thank you. And gentlemen, do you all understand you may not speak to anyone, including each other, about this hearing or the information divulged in this hearing? Violations of your oath and this order to be silent is punishable as contempt of court with up to 365 days in jail and a fine of $1,000. I just say that so you understand the importance of keeping the information that you hear in this courtroom here today to yourselves. And I trust you will follow that oath. Thank you, gentlemen. Mr. Baldwin, you may proceed. Attorney Baldwin. Thank you, Judge. These are very rare. So I don't want to I'm happy to produce witnesses, but I also wanted to see how much short circuit we can do, if any. Basically, this is not any surprise to anybody. At this stage of the game, we're really desperate for an investigator. That's the main thing that we're asking for. I have witnesses that can testify about how much work they put in as on a volunteer basis. So that's going to be one topic. Another topic is less important, and it is taxing for our staffs a little bit, and we're going. I think going to ask for some consideration of the possibility of money for time that our staffs are taking. That's my paralegal is here to talk about that if needed. And then we're not prepared because we're still going through the evidence. But we anticipate in the future we'll need another hearing related to ballistic experts. And depending on how the other pieces of evidence go, perhaps other things. Yeah, folks, I have a video on the ballistics evidence in this case. That the state ballistics expert with the cartridge found on the scene, when she tried to, it was a cycled cartridge, not a fired one. Then she took Rick's gun, cycled it, and it wasn't a match. That is when she should have stopped her comparison. It was not a match with the cartridge that was found between the girls. Instead, what she did, she fired a cartridge through Rick's gun and then compared it to the unspent cartridge on the scene and claimed it was a match. I have a video from a few months ago, and I will say it out loud. She was lying. It's not. It's not a match. It is not a match. But her mission was to find a match, and she lied that it was a match. In my opinion, she claimed that and by the way, folks, I've said this so many times, and I will say it again. Ballistic comparison is not a science. It never have been. You might as well get a tarot reader. It is that bad. It's not a science, folks. It never was, never will be. It's shit. It's shit science, false science. And it's still being used in courts is an abomination, an absolute abomination. All right, let's get back to this. So I'm happy to put on evidence that I think will help the court understand kind of the dilemma we're in. The court, okay, you may proceed. Mr. Baldwin, okay. Matt Hoffman, witness sworn. Go ahead, Mr. Baldwin, thank you. Direct examination of Matthew Hoffman. Questions by Mr. Baldwin. I will just say QA. Q for question, A for answer. Q, state your name for the record. A, Matthew Hoffman. Q, and spell your last name for the record. Hoffman. Answer Hoffman. Q, all right. I'm just going to kind of lead you here. Since it's quasi-informal, but basically you start, you volunteer to help out on this case. Is that correct? Answer, yes. Q, you're retired. Give the judge some brief background. A, I am a retired firefighter. I've been in the public safety realm for about 35 years. I currently work as a contractor with the state of Indiana, part of Homeland Security and Indiana National Guard. Q. Now, at the time that you offered your services, and we've known each other for a long time, you were between a job and a job that's going to be starting in the future, in that little window. A. Yes, in between two contracts, one ended and the other one had yet to start up. Q. So tell the judge a little bit about what I have asked you to do, or what Brad and I have asked you to do, and what you've been doing. A. Yes, so get tips and leads from the general public, and they asked me if I would do my best to follow up on those leads and tips and interview the people who were providing information, either phoned in, emailed in, texted in. Q. We had some mail come in too as well, packages. A. Yes, yes. Q. How many different people have roughly, would you say, have phoned in, emailed, texted, or sent in packages? A. My estimate would be that we're getting close to 100 at least. Q. And out of that, how many have you returned phone calls to or contacted, communicated in some way? A. 15. Q. All right. And kind of go through the process with the judge so she understands. A. So what I do is we kind of break down of what we think the tip is going to be about based on the message that was left and how credible we think some of the information sounds. We prioritize it, and then I do phone interviews. And I record the date, the time that I'm making the phone call, and then I have a phone conversation. And those phone conversations last anywhere from 5 to 10 minutes all the way up. The longest one I've had was almost 2 hours. Q. And what is the purpose of those phone calls? A. So usually the people will give me their background on what they think they have. That's interesting, or that would find interesting. And so they offer potential suspect, they offer potential pieces of evidence, things like that. Q. What roughly percentage have of the 15 that you actually talk to do you think are there? We don't ever need to talk to that person again versus, yeah, we need to follow it up. A. Of the 15 I've completed to this point, I would say we probably should be taken seriously and follow up with at least half of those, if not more. Q. And can we give an idea to the judge on what follow-up means to you with these people that would kind of look like? A. Anything that what it would look like in terms of we contact them again, either in person or telephone conversations. Q. Can you think of a particular one that's of interest? One of the people that have contacted us that you think, quote, this is really important that we follow up. Can you think of one in your brain right now? A. Yes. Q. Okay. I want you to tell the judge what would you expect beyond just talking to them that would follow up is going to entail in terms of legwork. A. This particular person that I had one of the longer conversations with, that was one that was almost 2 hours. They live in Missouri, and the individual that they were concerned about also lives in Missouri, but travels frequently to the area. The person is a family member and they noticed that each time this member of their family is out of time, there seems to be some sort of an event that happened in the area they're visiting that makes the news. And so they're like, quote, this is just happening way too often. And I've got receipts of where this person has been and such. So they had quite a bit of information, and they had quite a bit of evidence to back up what they are saying. Q. Okay. And that's what I wanted to get to. I mean, A. Yes. Q. It sounds kind of crazy, that, we're getting some crazies out there that are calling. A. Yep. Q. But this is one example, just one that cost you like, okay, this is not, yes, this is worth investigating. Yes. How many hours, Q, how many hours of volunteer time do you think you were putting in per week or per day? A. When I was between contracts, I was probably putting towards 30 to 35 hours a week. Since my new contract was picked up, it's been scaled back significantly to maybe 5 hours a week at best. Q, you're not an investigator. Is that correct? A, that's correct. Q, all right. And do you think that an investigator you would be able to communicate with an investigator to follow up on those leads? A, yes. Q, and also, we still have roughly 80 to 90, maybe even more people that we've got to contact. Is that right? A, yes. And there are people who send in regular bits of information as they come across it. So, Q, good point. The number of people versus the volume. A, yes. Q, The information is inaudible. Here's what I'm going to do. I'm going to start one of these. This will become important, folks. Because I've been skimming through this, and I have seen other people skimming through who are way ahead of me. The number of inaudible in these records are high, where somehow this court reporter Jody chooses to not hear or doesn't hear, to the extent that either she has a severe hearing disability or she doesn't want the information in the transcripts. It is, in my opinion, a number that would make it an appellate issue in itself, because it makes the transcript, the actual trial transcript, incomplete. And that is a huge issue when it comes to appeals. Huge issue. So I will keep count. The volume of information is more than the people. Yes? Q. And we got a chance to follow up. Like if somebody sent in a multitude of pieces of information, have you had an opportunity to even follow up on this individual? A. No, sir. Q. We do have a collated spread, not a spreadsheet, a piece information where all of these people and their phone numbers and A. Yes. Q. Contacts are. That's part of the purpose. Yes. A. Yes. Mr. Baldwin, all right, I have no other questions. The judge may have questions for you, though. Cross-examination of Hoffman. Questions by the court. Q. What is your hourly rate? A. I'm a volunteer. Mr. Baldwin, yeah, Judge, we're not expecting him to be a detective. The purpose of his testimony is really just to give you an understanding of what we're dealing with. The court, okay. Mr. Baldwin, in one area. The court, all right, thank you, sir. You may step down. The witness, thank you. Mr. Baldwin, call Sarah. She's super nervous. The witness public speaking is why I'm not an attorney. Witness sworn in. Questions by Mr. Baldwin. Q. State the name for the record. A. Sarah Easter. Q. Sarah's a couple of different ways of spelling. A, H is on there or no? H at the end, yes. Easter, yes. Okay, what do you do? A. I'm your paralegal. Q. Since we got on this case, can you kind of give the judge an idea of additional work, if any, that you have to perform? A. A lot of the people that call into our offices with tips and information, I speak with them and get a general idea of what it is they want to share with us, along with their contact information. Some of those are quick calls, some of those can take a while. Q. We had a lengthier one yesterday. A. 2 days ago, I was on the phone for about 30 to 40 minutes with someone, just getting general information from them. And then I work on the spreadsheet that was discussed, entering everything in so that we can keep track of it, as well as any mail that comes in, emails that we receive. I catalog all of it and save it to our online or our system of keeping files. Q. Is it fair to say that every single day we're getting emails? A. Yes. Q. Multiple emails. A. Yes. Q. Beyond that, we got this first round of voluminous discovery. What's your kind of role with that? A. I will be going through and catalog it, naming it appropriately for our office so that we know what it is and put it in our system, just kind of cataloging it and sorting it so it's easy for you to access. Q. And I know it's impossible really to say how long that is going to take, but knowing that there's going to be even way more than we already have, how many hours per week would you guess that just cataloging the evidence is going to take? A. On top of the other duties that I have with other cases, I would guess for this, I'll be doing anywhere between 7 to 9 hours a week just working on getting that in our system. Q, okay. But that's at some point in time that will end. But A, yes, yeah. And how many hours, even it's an hour, would you say you're dealing with per week with A, just the calls? Q, calls and emails. Probably 2 to 3 hours. Mr. Baldwin, that's all the questions I have. The court, okay, thank you, Miss Easter. You did great. Mr. Baldwin, Judge, I have from one thing you may want to know is is how much does it cost for an investigator? We've been talking with a couple. The range seems to be from $60 at the low end to roughly 75. That's the kind of small range of these. The court per hour, Mr. Baldwin, per hour. The court $60 to $75 an hour. Okay. But Mr. Baldwin per hour. I think the rest of what I'm going to be talking, we're going to be is just argument. Well, I don't even know if it's argument. Just telling you about kind of what we need. Is that okay? The court. Okay. Mr. Baldwin, you know, I've been doing this almost 30 years. I'm in my 29th year. I've had some big cases with lots of evidence and lots of discovery that is manageable. Maybe it wouldn't be manageable in another law firm, but ours is pretty well organized, and I feel we can handle a lot. We cannot handle this. Between me and Brad, it's every day. I mean, even his staff gets stuff that they send to us, and then we put it into our spreadsheet. And I would say that there are, just like Mr. Hoffman said a second ago, there's lots of suspects out there that we're getting information about, and we're very cautious. I feel like we are at least two, and when we talk to, be careful about not omitting people. Like this Missouri business, for example. It seems pretty far-fetched to me that some guy from Missouri driving out, yet there is what I would generally label receipts out there about this is a possibility. And as a defense lawyer, the one thing you do not want to do is learn 20 years from now, when Rick is sitting in prison, that we found a guy, DNA or whatever has turned up, and you didn't. Oh, that was the guy that we kind of brushed off. So what we need is an investigator that really is an expert in talking to people and vetting, more so than Matt. I mean, Matt's, he has some experience in that realm, but not the type that we need. And I appreciate his help big time, because without him, we would be really way behind. But I feel like if we have even one investigator full-time, 40 hours a week, that's still going to be a lot of work for them. Because not only do they have to go through the vetting of the information that we're getting, that's just one part of this thing. Then they have to follow up on all the stuff by going out and talking to people or finding and following up on that stuff. And then, by the way, we have discovery. So, and we haven't even looked at all of the witnesses that are all of their statements, and going out and talking to these people from the state's discovery. So it's multifaceted. We really need a full-time investigator. I mean, I'm not going to sit here and say we could use 5 full-time investigators, but initially, just to kind of catch up to where the state is, since they've had 5 years of working on this, but we're asking for now for one full-time investigator. You know, when I've asked for this kind of thing in the past, different, you probably have your own way of doing it. Just for me, it's normally what will happen in some courts, at least, is, quote unquote, here's your first limit. It's kind of like you have X amount, and once you hit that, then, you'd come back and ask and explain why you're spending taxpayer money beyond of that or need more money. Whether it's that or just authorizing a 40-hour investigator a week or whatever, we need something, and we need that, as soon as possible, and appreciate the court's consideration on that. As it relates, I'm not as far as office staff and stuff. I mean, I think part of it is, when you take on a gig like this, your office is involved in it. You shouldn't really, to some degree. I've never asked for my office staff on cases where I've been asked to be a special or a defense lawyer or public defender. When judges have made that request in the past, I just don't ask for my staff to be billed for. I do think it's been this busy, as both of our practices are. It is a request that I would ask that we can bill. It doesn't have to be a whole lot, but just something, knowing that we got a little bit of extra money coming in. Just as Sarah said, she has a lot of other obligations, and so she's staying till 6, 7 o'clock at night sometimes, so that she can finish her work on or try to stay updated on the Allen case. So I think my request would be, maybe 5 hours a week. And I didn't even ask I don't even know what we pay you. Miss Easter, like my hourly rate? I'm not sure. Mr. Baldwin, she paid the salary, so I think $15 an hour. I think we pay more than that, but I'm very cognizant. I'm a taxpayer. I don't like people coming in and taking advantage of a big pot out there. That's not my style. I don't like it, but as a small business owner, it's something that could help us defray some of it. I think Brad probably feels the same way. I'll let him talk to you about that. And then judge. The other stuff, as I said earlier, once we get into this, we know we're going to need a ballistics expert, but we're going to save that for a different day. We still have a lot of people to talk to. We have experts that we used in the past on ballistics, so we're going to determine that and try to find the best person that makes sense financially as well. So is there anything you want to say? Yeah, by the way, folks, ultimately, Judge Gull denied the defense ballistics expert to testify. Denied it. Oh, thank you, Derek. Thank you so much. For £3, it is an apple with boxing gloves for your super sticker. Thank you so much. That is so nice of you. So nice of you. Attorney Bradley Rossi, Judge the court, Mr. Rossi. Mr. Rossi, if I could, I have a few comments. I mean, obviously, we're working, and Andy's office and my office are 70 miles apart. So I'm not exactly sure what's going on physically there, other than he's telling you, or I assume from some of the dealings here. But I've got two burdens of my staff, so kind of characterize this. One of them is the need to have Max Baker around, who's sitting here, and Max have worked diligently on this venue issue. You can see I've got binders in front of me that are fully tabbed and ready to go today, which is fine. We didn't need them, but Max was responsible for a lot of the information that was included in the original request to move this case that you saw. And Max is going to continue to be involved because I need him to be in another facet, and that is that as these truckloads of discovery coming in, rather than me at my hourly rate, clicking and pointing on every little link. I think it's a little bit more efficient to have Max, in some cases, go through some of those circumstances and try to vet out what really matters and what doesn't, because in fairness, I want to say we got an Excel spreadsheet from the state. Well, I tell you, when they delivered the original packet of discovery to me, when we picked it up here, Nick, it was all on a thumb drive. The first phase, which was amazing to me that we're doing that. It was a 256 gigabyte thumb drive. But he also handed my paralegal a stack of papers that I'm going to say is 150 to 200 pages, and it is Excel spreadsheets. Line by line, probably six font. You can't read them without a glass to look at it. You can't read them, and there's probably 200 pages of line items of various things, whether it be tip line information or discovery, photographs or whatever. I mean, it's just item by item of every possible thing you can fathom in this case. But there's a stack of papers it's probably 3-4 inches tall. And that's just one round. So Nick essentially was handing me Excel sheets of just the numerical items in varying forms, formats, whatever, just to give you some idea of the volume. I mean, there might have been 75 lines on each of those sheets, maybe 100. Some of that are a lot of duplicate photos and things like that. But my point is, I think it's cheaper for me to have Max spend 10 hours a week, and I'm paying him, well, he's an intern, but I'm paying him $10 an hour. You got to understand, he's also driving 2.5 hours to come back to my office from Bloomington to work when I need him in the office. And he's been there quite a bit lately. So I'm paying him $10 an hour. He's interested in this profession, so there's a benefit there. But I think it's reasonable thinking about the gas so that he can get back to the office. And I certainly don't want a lot of this information floating around down in Monroe in Bloomington either. You know what I mean? Like, I don't want to give him a file. I'm even a little concerned about electronic information flying back and forth. And I will say in that respect that I'm going to transition to my staff, my paralegal, whose name is also Sarah with an H. Sarah Luxembourg is her name. She's not here today. She, I would suggest, is putting in about 10 hours extra a week on this case. Very similar to what Sarah Easter is doing. But one of the things that my Sarah is doing is she's on the road. Nik has chosen to give us discovery in person as opposed to emailing us the stuff, which again, I'm not opposed to right now. But she's been making trips over here to get information, and then we're delivering that down to Indianapolis, to either Noblesville, his office in Noblesville, or whatever, the parking lot meeting, one of those deals exchange. So there's also the additional cost of those expenses that comes with this. And again, we haven't even really gotten into vetting discovery. One of the runs of discovery has been cataloged. I think the outline that I saw was 15 pages, and I don't, maybe more than I have. Actually, it's right here in front of me. The point is that, I'm thinking about 10 hours a week. I'm not trying to undercut anybody here, but I think I'm paying Sarah $20 an hour or 19 something maybe, just to give you some idea what the market's like in our area. She's also been with me for 23 years, as long as I've been doing this, so that's where she is. But those are things that, that I'm experiencing. And then the one thing I do want to comment about, these tips and stuff, which is probably the most frustrating part of this case, honestly. I was telling Rick that I decided one Saturday morning I was going to call a couple of those people back. And I dialed the first number that I had, and some woman in Cincinnati. And I'm telling you, for 45 minutes. Now, I could have hung up the phone, but I just felt at that point I needed to hear what we're dealing with to get an idea. And there's literally, he said, we had 100 so far. The state has thousands of those cataloged, and they've given those to us in Excel format. So they have their catalog of 5 years of people that have called in and name and number on all that kind of stuff. Do I have any intention of calling those people back? Clearly not. But it's there, and the state has talked to those people. And I would say, finally, the idea of Andy talked about, other suspects or that kind of, that idea that there's somebody in Missouri traveling here. We're not. This isn't necessarily us trying to create that narrative as much as it is to vet out the state's narrative. Because the discovery itself, I'm reporting to you, has a whole panoply of that in it. And I'm using this term loosely, the state has its own laundry list or long list of suspects. It's that kind of case, and they got slideshows. I'm looking for the word, not slideshows, but Mr. Baldwin says PowerPoint. Mr. Rossi, PowerPoint, thank you. Yeah, folks. At this time, they are still months away from learning that the state, the investigators, deleted the first 70 days of interviews. They are still unaware of that fact at this point in time. Mr. Rossi, PowerPoint, thank you. They got PowerPoint, PowerPoints made of these suspects. And so some of it is just us kind of doing similar work that they were doing. But just to give you some idea of the scope of this stuff. And look, when I took this case on, I knew that this was coming. I certainly didn't understand the scope of it until I get in the middle of it. But I'm not sitting here suggesting that I had no idea that Sarah and my office was going to be burdened by it. But I'm just sharing with you the reality of lawyers who want to work in this field and also need to continue to maintain a practice. That's what we're dealing with. And so I'm just sharing with the court as an officer of the court. Mr. Baldwin. One last thing, Judge. Matt Hoffman has been doing really, I appreciate so much how he's helped. If we could continue to use his help on a part-time basis, but I wouldn't want him to continue without pay. So I would ask the court to consider as part of it like 15 an hour to up to maybe 10 hours a week or something like that, if the court thinks, based upon what everything we've said and represented, would make that a necessity. But again, I'm mindful, I'm a taxpayer myself, I understand money. So, Mr. Rossi, and I've been working with Max too. inaudible. Second, inaudible. So he and I have been working together remotely. So, but you know, it's been a part of assisting me in some of the early goings, and I think that's going to continue. The court, anything else? Mr. Rossi? No, ma'am. The court, okay. Having done a couple of death penalty cases, several life without parole cases, I'm unfortunately quite familiar with the needs that you have, and I have no problem approving funds. Spoiler! We had to fundraise to get Rick experts because shortly before trial, the prosecution all of a sudden, oh, we have these people who are going to testify as well, unknown to the defense. And Judge Gull denied funds for additional experts. So me and a bunch of others fundraised for those experts. That is what Judge Gull does. And I read through the documents with the approval of costs and stuff. Here is the evilness of Judge Gull. She denied funds to some experts. She approved funds of other experts. This was before the additional experts. They got those experts with approved funds, vetted everything, and then Judge Gull denied them to testify in court. She only had them to spend the money they got, and then she denied those experts to testify. Yeah, it's unimaginable evil. It's so calculated as well, because at that point in time, she knew all this. She knew before she approved the cost of a certain expert that she will never allow that expert to testify. It is insanely evil. Insanely. So as we move on with all the transcripts, you will understand when I say, and I've said this a lot of times, we wish we had Judge Bev on the Delphi case. I wasn't kidding or being hyperbole about it. We wish we had Judge Bev on the Delphi case. All right, let's continue. I think I told you this earlier. I'm going to meet with a member of county council to find out what the funds availability are. I'd like you. I don't have a problem with reimbursing Mr. Hoffman and giving you money for that. Paying for your paralegals, paying for your private investigators. I have no problem with any of that. She will have problem with that, by the way. I'll issue an order detailing my comments to you about what is Max's last name? Baker. The court, I got Sarah Luxembourg. Rossi, yes. Luxembourg, N or N? N. N as in Nancy, yes. Okay, I got Miss Easter's name, Easter. Common spelling like Easter, Happy Easter. And Mr. Hoffman, I don't. Do you have an investigator in mind? Or you just kind of thought about the range of money that you would need for an investigator is 60 to 70 bucks? Mr. Baldwin, right. We got a couple of. I've talked to Brad and the court, okay. Mr. Baldwin, he's in charge of that part of it, the court. So we talked about an investigator, your paralegal, Miss Easter, Mr. Baker, Miss Luxembourg, your paralegal, and some additional money for Mr. Hoffman, if it continues as well. Okay, I guess my thought would be, I know in your motion you asked to be able to just submit those directly to the auditor. I'll speak with the auditor and find out what her thoughts, her or his, I don't know who it is, what their thoughts are. Leslie Owen is my financial coordinator, very familiar with processing invoices, very familiar with dealing with Mr. Rossi. Did you say Owen? The court, Owen, Leslie Owen, Ross now. I'm sorry, now it's Leslie Ross. She's the financial coordinator for Allen Superior Court. I'll probably have you submit your invoices directly to her so that she can make it sure that they're in proper form and get them to the auditor. That way when I was appointed special judge, I know that the process here in Carroll Circuit Court is a little bit different than what I'm familiar with. The court staff has been handling a lot of that, handles a lot of that for the court. Mr. Rossi, Karen Allen. The court, yes, which is probably not appropriate in this situation. So if I can deal with it directly with my coordinator and the auditor, I would prefer to do that, so that we don't have an issue with any of the court staff talking about things or sharing information that should not be talked about nor shared. Mr. Rossi, and I appreciate that. I actually hadn't thought about that. I talked to Karen a month ago about the mechanics of all this. The court, yeah. Mr. Rossi, and she was very helpful, but the court, yes. So, Mr. Rossi, so do you have contact information for Ms. Ross that, like an email or, something? The court, I will get that to you, yes. I will get contact information. She's here someplace. I think she's waiting. Mr. Rossi, so I think that if I'm not mistaken, what you're saying is just any of the financial that arises from this case, we just push them to her. The court, correct. Mr. Rossi, okay. The court, correct. Okay, anything else? Mr. Rossi, no, ma'am. Mr. Baldwin, so either our own, we have not billed yet as attorneys, so we should submit to Ms. Ross. Yes. Okay. Yes, okay. Here's the thing, folks. I've talked about this in prior streams. Attorney Baldwin and Rossi weren't paid, I believe, from April or May of 2023 into 2024. Judge Gall refused to approve their invoices for over a year because she started to not like them. Again, we wish we had Judge Bev on this. Nobody got paid for over a year. It's insanity. Direct examination of Sarah Easter. Mr. Rossi, Judge, I. The court, yes. Mr. Rossi, I do have a question about that. The bill on the billing statements. I know that these will be scrutinized. I'm preparing for that. That's not normal. When I get into these cases, typically I'm working with the police department's office in Lafayette. We send the bill over, and generally, it gets paid, and that's it. But obviously, the detail and what you put into your statements, does speak to what you're doing from a work product standpoint. The court, yes. And so I've always tried to toe the line between, enough to, but not too much kind of thing. You know what I'm saying? The court, yes. Mr. Rossi, and so I just want the court to be conscious of that's kind of, those are the things I'm thinking about when I'm submitting these. Mr. Baldwin, and if you need more detail, because a lot of mine might just be reviewing discovery. If you need reviewing discovery related to a certain topic or something, happy to do that too. The court, okay. Mr. Baldwin, so just, of course, that you can do that. I'm not trying to tell you what you can. Feel free to yell at us or whatever. The court, I don't yell. Need detail or whatever. The court, I don't yell. Need more detail. All right. Thank you, gentlemen. Thank you. Thank you, lady. Thank you. The court, okay, Jody, you can go off the record. This concludes the proceedings held at the ex parte hearing held January 13th, 2023 in this cause. So this tells me that this court, if the defense needs an ex parte, everything is recorded. The prosecution's ex parte with Judge Diener, why isn't that part of the record? Yeah, She didn't even allow their experts to as rebuttal witnesses. It's insanity. But at this point in time, she didn't hate the attorneys. She started to in later hearings, especially at the time of the Franks motion. That is when she went off the rails. Liz Birdwatt, the prosecution's ex parte warrant on the record? No, it's not a part of the appellate transcript. The ex parte meeting where Rick Allen was deemed to be safer in prison than in jail. Mr. Allen wasn't even at that hearing. Mr. Allen's attorney at the time wasn't even notified that there was a meeting between prosecutor and Judge Diener. And it's not in this transcript. And I keep filling you in with stuff I know, but this is mostly to get everything on video and on stream, so you can hear, you can ask questions. If I see, at least, so approve the funding for the expert, then deny them going on the stand. Yeah, it is calculated evilness from Judge Gull. Calculated evilness. Nicola Cox, how do they get away with it? Because they think they can. Because they think they can. And they basically did. So far. That is why we need to keep our eyes on this case. I mean, we really don't have a choice if we want justice for Abby and Libby and getting Rick Allen out of prison. Because whoever killed the girls are still out there. And maybe they got a taste of blood. And out there, planning for their next victim, if not already found a new victim. This case might have taught the Abby's and Libby's killers, oh, we need to do this better. There might be missing kids all over Indiana that we don't know of. Because they arrested Rick Allen and they didn't care about the other suspects. A few days ago, I had a stream about the Odinist report, the 12-page Odinist report that was a part of it was referenced in the Franks motion. But now we got the 12-page summary. There, behind the 12-page summary is an 85-page report that we still don't have. And it is damning against certain individuals claiming to be ACER believers. It's really damning. And yeah, I know, Andy. I know you're working on it. That is so great. Thank you so much. Now, another thing that I kind of need to talk to you about now in between these. You all have heard about maybe the Michael Fosler case. Aaron Spencer is at the moment charged with murdering a pedo. Michael Fosler was charged with 43 acts of things towards Aaron's daughter. He did it the legal way. Michael Fosler was sent off to a judge who decided, no, $50,000 bail without restrictions. That's enough for this predator. Michael Fosler then out of jail, posted bond, out of jail, and a couple of days later kidnapped Aaron Spencer's daughter, 13-year-old daughter. Aaron Spencer noticed that his daughters were gone, went out looking for her. By chance, saw his daughter with Michael Fosler in his truck. He made it go off the road. There was an altercation. Aaron Spencer believed Mr. Fosler had some kind of weapon and shot him dead. Now Aaron Spencer is charged with second-degree murder. Why am I mentioning this? Because Michael Fosler grew up 80 minutes from Delphi, Indiana, in Hamlet, Indiana. He was a cop in Hamlet, Indiana in the 1980s. Where he hung around schools. There are probably a lot of victims of Michael Fosler out there, starting probably earlier than the 1980s. He was also a school resource officer in another town in Indiana. There will probably be victims of him there as well. Michael Fosler is the same age as Keegan Kline's father. They lived an hour apart. Same age. Same MO. Like girls of the same age group. We are still in the information gathering phase to find, because as of now, there are only fuzzy links between Michael Fosler and the Delphi case. In that, Michael Fosler was of a prominent Freemasons family in Hamlet, Indiana. The same Order of the Eastern Star as a few of the interesting people in the Delphi case. We are still trying to find direct connections. Not that it might have been him, because it probably wasn't. But we are in the beginnings of discovering a generational pedo ring in Indiana, if we get the correct information. Problem is that it was 1980s, 1990s. And Michael Fosler was a cop who suddenly left the force, joined the army, and moved to Arkansas. I would assume that it was because somebody discovered him raping girls and thought it would be a better idea to scrub the record and tell him to fuck off. All of these might be coincidences. I don't think so, but finding the direct connections will be hard, because cops protecting cops. So I thought I'd just bring that in, because I really can't do separate videos on YouTube about Michael Fosler and the Aaron Spencer case, because shadow ban. People who have tried to make videos and streams about Michael Fosler they have maybe 1/10 of the views as they normally have, even some larger accounts. So instead of doing separate, I am using this stream where we are almost 3 hours in to mention it. That there might be a connection between Michael Fosler and the Delphi murders. So now you're aware of that. Now you're aware of that. All right, we are 3 hours in. We're only on page 63 of the first one. Which one is the next? Record of hearing held February 17th, 2023. How long is this? Page 64. Let's see here how long it is. All right, I will do this one as well. I will do this one as well. Timo's Wrath says, I can't understand the whole sweep the grape under the carpet idea. Yeah, me neither. But it's happening. It's happening. And all we can do is make people aware of it. All right. Let's see here. Let's put us. Again, that would be the Norwegian fire farting dragon. You cannot sneak up on that from behind. Again, a reminder, hit the thumbs up. You know how to do it. That is to get more people aware of this. We are currently at 174 likes, which is great because we have 136 live viewers. But I also see that we have over 700 unique views. So we are a bit behind. We are a bit behind. So if you haven't pressed the thumbs up yet, please do so. Please do so. All right. Record of hearing held February 17th, 2020. I need something to drink. Hold on. Hold on. While I get something to drink. I'll be right back. Da-da-da-da. Dun, dun, dun. Now it is 6 p.m. where I am. I'm having a beer. Oh, because yes, I could have water, but I'm thirsty, not dirty. All right. February 17th. Now, as I've said before, I will cut out the different reading of hearings to separate videos. I will name them, which hearing it is, what date it is, what type of hearing it is. That is for you to have all of this easily accessible. Because it's a this would be a probably a 4-hour stream. It's easier to that hearing in the beginning. What was that all about? And you can just go to the playlist and find the video for it, the cutout video for it. Makes it easier for everybody involved. All right, record of hearing held February 17th, 2023. Appearances: McClelland, go fuck yourself, Rossi and Baldwin. The dishonorable Francis S.C. Goal, and reporter Jody Williams. Proceedings, the court. Well, good afternoon, everybody. Mr. George James, Brad Rossi and Nick. Andrew Baldwin, good afternoon. McClelland, good afternoon. The court, all right. So, Mr. Rossi, there we go. Mr. IDMs, I can pin a certain person, Judge. The court, I'm sorry. Mr. I. James, I have no idea who that is. Do you want me to pin somebody in the middle? The court, doesn't matter. Okay. Can we unmute everybody, please? Yes, I'm not sure if Westwill will allow him unmuted. I'm not sure because that's on their end. Mr. I. James, I think, well, it looks like he's looking. The court, okay, he's checking at the door apparently. Okay. Hey, Mr. Allen, we can hear you now. The defendant, oh. The court, we can hear you now. Thank you. The defendant, sorry. The court, okay. No, that's okay. That's fine. I know originally you were muted and we couldn't hear you. So I know you were clamoring for somebody to help, but our ET person got you unmuted. All right. We're here on State of Indiana versus Richard Allen. I'll show that Mr. Allen is here with Mr. Baldwin and Mr. Rossi. The state is here by Mr. McLeland. With the consent of the parties, we are doing this by Zoom so that we can address the defendant's petition to let bail. Mr. Rossi, you filed a motion to continue that hearing as well as a motion to continue the trial. You may proceed, sir. Attorney Rossi. Judge, you'll have to forgive me. The audio, inaudible. That gets us to... Now, this is via Zoom, so it's more understandable, but inaudible, 3. I'll keep this counter because it will become important, not only the amount of inaudible. At some point in later hearings, answers and questions will be as inaudible, which is absolutely insane. Audio feedback. I'm getting a lot of feedback. The court, George. James, is that from the jail or us? The court may be from the jail. Mr. Rossi, okay. The court, okay. Mr. Rossi, yeah, I'm still getting inaudible. Or inaudible. And then 1, 2, 3 more inaudibles. Now, these are more understanding. So that gets us to 7. Not only inaudible, obviously the volume of discovery is inaudible. Between the state and the defendant is significant. That's an understatement. Mr. McLeland has worked inaudible, as have we, to arrange for things. I think there's 5 or so hard drives with several terabytes of information. Oh, thank you, Skeptic Curiosity, for being a member. Thank you so much. That is so nice of you. Thank you so much. The court, what is that? Mr. Rossi, that. Can you hear me up there? The court, hold on just 1 second. Can you mute Mr. Allen? I don't know if it's coming from there. All right, Mr. Rossi, try again. Mr. Rossi, go ahead. The court, there we go. Mr. Rossi, so there's a little better. The court, okay. The state has offered up, some discovery on Monday. Last possible second again. And we just haven't had a chance to really even dig into that at all at this point. And there's just no way practically that we can move forward with a bond hearing with at least having, reviewed on a basic level the discovery that has been offered up. And I'm guessing it's probably going to take us, 4 to 8 weeks to catalog this information and essentially just get some idea of what we're dealing with. There are some hardware challenges and some software challenges that comes with that. I think we were informed by Mr. McLeland's staff that it's going to take over a day to just download each of the disks and the hard drives independently. And I do think there are a few of the hard drives that I understand may have some problems. They're having some problems with the audio. Shocker. Those are things that Mr. McLeland's office and my office can work through, but, we've also had some discussions about the possibility of taking some depositions. So I would anticipate, to get to the heart of the matter, that we would want to set this bond hearing or this bail hearing out probably into May. The court, okay. Maybe mid-May might be appropriate. Mr. Baldwin, even June. Mr. Rossi, maybe June. The court, okay. And Mr. McLeland, you indicated, what is your position? Judge, Mr. McLeland, Judge, I have no objection to that. I understand the defense's motion. I filed a response to that motion, not objecting to continue the let bail hearing. I also have no objection to continuing the trial date as well, Judge. So this is in February. They have, this is where you see Rick Allen really deteriorating, losing a lot of weight. This is less than 2 months from when he gets starting to get force-fed Haldol, when his psychosis due to the solitary imprisonment really kicks off, and is force-fed Haldol. At this point in time, he has been with psychologist Walla, who has, in my opinion, been trying to get him to confess for some time, together with some of the prison staff. Psychologist Walla, if you hear this, I hope to God I never see you. I hope to God I will spend the rest of my life never meeting with you in person. I will record you, I will confront you, and I will not go away. I will not actively seek you out. But if I am in the neighborhood of wherever you are, I will have a recording device ready. And you better run. The court, okay, because I know we had talked earlier about discussing the March trial date and bond hearing. Obviously, if you're looking at a bail hearing sometime in May or June, clearly we're also, and you've also asked Mr. Rossi and Mr. Baldwin to continue the trial. I anticipated that that's where we're going to be with this. So I don't see that will really have an issue with continuing everything. Do you wish to give me some dates, mid-May and June? Mr. Baldwin, I wish I brought my glasses. Mr. Rossi, Judge, you know, I guess it's kind of one of those cases where, for the most part, I'm willing to make accommodations to the court schedule, knowing all the logistics. I don't have anything. I know I have one case that would matter, that would require, you know, us to meet, set aside a whole week. I think that's in July or August, though. I'm pretty good with any dates that can happen in May and most of June. The court, okay. Mr. McClelland, Judge, this is Nik McClelland. I just informed the court that the court's trial calendar, our trial weeks for May and June are the week of May 15th and then in June 5th. And I believe that covers us for both those months in terms of what weeks are set for jury trials in circuit. The court. Okay, so those are weeks that are not available for you and the court. Mr. McClelland, those weeks I'll be in trial in circuit court, and the circuit courtroom will be used for trials those 2 weeks, Judge. The court, okay, I got Jody looking now for a Friday without those dates in May or June. Jody. Mr. McClelland, Judge, the court reporter for circuit court also told me that the Judge Diener is gone the week of June 26, and so I thought he retired by then. All right. And so I know that's little bit later than what defense has recommended, but that week is wide open in terms of hearings in circuit court. The court, okay. Mr. Baldwin, this is for the record, Andrew Baldwin. I know it's way out, and Rick, it's maybe a bit longer out than Rick would want, but with 5 hard drives filled with stuff that we don't even know what it is yet. For that hearing to have any meaning, I would think that's an appropriate amount of time. But I haven't talked to Brad about it. Of course, he may disagree. Mr. Rossi, I do not. June 30th is fine, or the week of June 26, I guess, to be more precise. The court, I can't do that week. I'm teaching that entire week. That's why Judge Diener is gone as well. She's teaching. Yes, folks. Judge Gull is teaching law at a local university. That abomination of Judge Gull is teaching law. Mr. Rossi, I'm fine with that. Mr. Baldwin, let me check. Mr. McClelland, Judge, might I ask, and maybe defense is better, well, how long does the court anticipate this let bail hearing to take? The court, well, it's on you, Mr. McClellan. I don't know how many witnesses you would anticipate calling. We can start as early as 8 o'clock in the morning on June 16th and go till we're done. Mr. McClellan, if it takes more than the day, is the court concerned that that's a Friday and we're in have the weekend splitting between that? The court, no, I'm not, unless you are. Mr. McClellan, no, that's fine, Judge. The court, okay, I mean, do you anticipate in taking more than a day? That's what we had it set for originally. Mr. McClellan, I don't think so, at least from my standpoint, Judge. In terms of the evidence I'm going to put on, I don't anticipate it taking more than that, but I'm not sure what. Then maybe the defense doesn't know at this point what, if any, evidence they anticipate putting on. Mr. Baldwin, I'd say that's hard to say. If we put on any evidence, what it would be, just because we haven't really gone through this, especially the stuff we got on Monday. So I don't know. Brad, do you have an opinion on that? Mr. Rossi, I think there's a possibility, just to be safe, that we could tee it up on Thursday instead of Friday. The court, if we have to, I mean, my trial schedule is I'm in a trial every week from now until the end of my career, if I feel like. So I can have one of my colleagues cover something if you want to start on June 15, and we could do the 15th and the 16th. Mr. Rossi, I think that sounds like a reasonable way to approach this, because you never know with just all the logistics. We could have things that cost some delay, maybe some technical issues, who knows? I think Thursday's a better day if we can do that. The court, do you want the 16th as well? Mr. Baldwin, I agree, yes. Mr. Rossi, yeah, 15th and 16th. The court, all right. What time do you want to start? 8, 8:30? I'm fine with either. Mr. Baldwin, yeah. Mr. McClellan, I don't have an opinion, Judge. Whatever is most convenient for the court is fine with me. The court, okay. Why don't we go June 15th at 8:30, and we'll reconvene on June 16th if we need to. That way, we got both of those days set. Mr. Rossi, very good. Mr. Baldwin, awesome. The court, okay, do you want to go ahead and pick trial dates? Mr. Rossi, I mean, does that seem a bit premature? If the court, I'm going to judge, I'll kind of defer to you on this. I mean, if you're more comfortable just having a couple of dates on the calendar so the media have something to talk about, that's okay with me. But I don't know if I'm fine if we just waited until June and discussed it personally. Mr. Baldwin, yeah, we're starting, Brad and I, Judge, are starting to realize the kind of enormity. If we didn't already know it before, we now know it for sure of the ask at hand. And, you know, I don't know your style of Judge. I heard a lot of good things about you. Really? I think that's just buttering up. You know, your style, very straightforward and so forth. So I'll be straightforward. I don't see this thing getting tried. It would be shocking to me if we could be ready by the end of the year. I just don't see that. Brad, and I'm speaking out of school. Mr. Rossi, no, I think that's a fair assessment based on what we've been confronted with discovery. Mr. Baldwin, I'm sorry to say that, Rick, but Mr. Rossi, yeah, Mr. Baldwin, but it's up to the judge anyway, so it may not matter. The court, well, I mean, just as long as we all understand, gentlemen, that this is being continued on defense motion, so all of the criminal Rule 4 time is counting against you. Mr. Baldwin, yes. And clear. And I know that you had conversation with Mr. Allen about criminal Rule 4 and the import of that. So, I mean, if you want to have a trial setting on June 15, then we come down to do the bond hearing. I'm happy to do that as long as everybody understands the clock is ticking against the defendant. Mr. Baldwin, yes. Mr. Rossi, I understand that, Judge, and I think you know the intention. We're talking kind of outside the courtroom here, and the intention is for us to order up some depositions in April and May, and I really think that the defense will have a much better idea on how to address some of these timing issues once those are finished. So, you know, if we bump this out into June and just address them at the June bond hearing, I think that makes sense. They still don't know what's ahead of them. They still don't know. Because at this point in time, the state hasn't broken Rick yet. At this point in time, Rick Allen is just on his way to a full-blown psychosis. He's on the way to being force-fed Haldol. The court. Mr. McLeland, what is your position on that? Mr. McLeland, judge again. As long as it's clear that the time for criminal purposes is taken against the defense, then I'm not in a position to object. I understand it's a tremendous amount of discovery to go through, and so as long as it's on defense motion, the state doesn't object. The court. Okay, then. I will grant the motion to continue the trial and schedule this for trial setting June 15th at 8:30 in Carroll Circuit Court. I will have the motion to transport Mr. Allen to the Carroll Circuit Court for that morning for that hearing, and if we need to keep him overnight, and if we need him on the 16th, I guess my preference would be not to transport him back and forth for his comfort. Mr. Rossi, that's acceptable. The court, okay. Is there anything else on the record that we need to talk about, Mr. Rossi? Mr. Rossi, no, ma'am. The court, Mr. Baldwin. No, Your Honor. Thank you. Mr. McLeland. Mr. McLeland, Judge, I did file a motion for a protective order for discovery purposes. It's probably covered under the gag order, the court order, but I thought perhaps maybe we should address that on the June 15th date or beforehand, whatever the court deems appropriate. The court, have you had the opportunity to review that, Mr. Baldwin? Mr. Rossi, the motion for a protective order? Mr. Rossi, I have. The court, what is your... Mr. Baldwin, yes. The court position on it. Mr. Rossi, Judge, I don't really have any kind of consultation about it. The court, okay. Mr. Rossi, there's a paragraph in the order. If I could just mention, paragraph 5 in the order basically prohibits, anyone that we would share, but it requires us to redact, personal information, identifying information, in the event we share it with any experts. And I can just tell the court, that's going to be a pretty tall task considering, again, the voluminous nature of the discovery. I don't want to get overly mired down in the technicalities here, but I suspect the prosecutor's office has done a lot of that through their software program already. I do think that you're going to get a good faith, effort by the defense. If we were to share this with someone, that we're going to make a good faith effort to protect that information. But for us to hold us to that high standard of redaction of all the information, I think is a bit overreaching. The court, what are your thoughts, Mr. McLeland? Mr. McLeland, Judge, we have done our best to redact the protected information. The state's theory is that if we missed something just because of the voluminous nature of the discovery, that if that stuff is released to an outside party, whether it be an expert or someone else on the defense team, that information could possibly get out and hurt either a witness or somebody else involved in the case. So that is the reason for that, Judge. Again, we tried our best to redact all that information. We just want to make sure we protect all parties involved. The court, okay, all right. Mr. Rossi, Your Honor. The court, I don't have a problem. Go ahead. Ms. Rossi, yeah, just offered a solution here, Judge. Look, I'd be happy to retain a ledger of anyone that we generate or offer this information to during the course of this case as a confidential ledger, and then have them sign an NDA agreement that just says, hey, you can't distribute or disseminate any of the information, and I think that's satisfying. The court, that concern. The court, I think that's a good idea. Thank you, Mr. Rossi. I appreciate that offer. I'll go ahead and grant the motion then for protective order regarding discovery with that understanding with the defense that they'll keep a confidential log and instruction to anybody that they provide this to. I'm assuming we're talking investigators and experts. I can't imagine this going all over the place, so I'll hold you to that then, Mr. Rossi, Mr. Baldwin. Anything else from the defense? Mr. Rossi, no. The court, okay. Mr. Baldwin, no, Your Honor. The court, Mr. McLeland, did you have anything additional? Mr. McLeland, no, Your Honor. Well, I guess one more thing. I assume the omnibus hearing will be continuing to that June 15th date as well? The court, the what? The what again? Mr. McLeland, the omnibus hearing. The court, yes. Mr. McLeland, okay, Judge, nothing further from the state then. The court, okay, I will tell you that I have received another media interveners renewed motion to intervene and another motion to grant public access to the state's verified request to prohibit public access. I know it was filed. You have access to this, filed on February 10th. When you filed, Mr. McLeland, your request to prohibit public access, I opened up the information and affidavit for probable cause. The media is now demanding the motion didn't incorporate the actual request that you made. The media is now asking for that request. Mr. McLeland, Judge, I was trying to pull up that request quickly here, but the court, yeah, you filed it October 28th. Mr. Rossi, just to make sure I'm clear, when I looked at this, the media is asking him to disclose the formal pleading that he filed requesting confidentiality, right? The court, right. Mr. Rossi, Just the pleading. The court. Right. Mr. Rossi, okay, all right. To the extent we have a dog in the fight, I don't have any problem with the disclosure of it. The court, okay. Nick, Mr. McClellan, Judge, I'm not sorry. The court, go ahead. Mr. McClellan, thank you, Judge. Honestly, I don't have an issue with that. I believe the pleading just talks about why I conceal it in terms of the rule that I use. I can't seem to find the pleading now. I pulled it up. I should have pulled it up before today, Judge. I'm sorry. I didn't know we were going to address it today. You brought it up. I don't believe there's anything in the pleading. There it is. Let's see, Judge. Yes, the state doesn't have any objection with releasing that to the public as well. And again, it's just a standard pleading to keep the records prohibited, and it doesn't list any sensitive information in there that I can see in terms of witnesses or the other things that the state or that the court has determined should remain confidential. The court, okay, I didn't either. I looked at it, and I'm not sure why everybody's clamoring for this other than it's been sealed, so I'll grant that as well. All right, nothing else then we need to talk about on the record. All right, Mr. McClellan, no, Judge. The court, and thank you. I really do appreciate the consent of the parties to do this by Zoom. You saved me a 6-hour travel down and back, so thank you. I do very much appreciate that, gentlemen. Okay, see you in June. Thank you, George. You can. Mr. Baldwin, Rick, we'll talk to you soon. Mr. Rossi, Judge? The court, yes. Mr. Rossi, are we going to have maybe a telephone conference here after we have this hearing or? The court, yes. Mr. Rossi, okay. The court, I'll call you. Mr. Rossi, is your staff going direct? The court, I'll call you. Mr. Rossi, you're going to call us. Okay, very good. The court, yeah, all right. Mr. Rossi, thank you. This concludes the proceedings at hearing conducted February 17th, 2023 in this cause. Yeah, we're moving closer and closer to the dates where Rick Allen is completely breaking down in prison. At this time, Rossi and Baldwin has both visited Rick in prison. They have seen him deteriorate. They have seen the prison guards. They have seen the situation in where they are talking to Rick. So my criticism here is, why didn't you file a motion already? At this time, Judge Gull still kind of was indifferent, maybe even liked the defense. At this point in time, maybe they could have gotten Rick out of that prison. But they still thought this was a normal, although voluminous, a normal trial with a judge who was fair and a prosecutor that wasn't corrupt. This is interesting. Let's see here. Mr. Rossi, are we going to have maybe a telephone conference here after this hearing or blah, 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 blah? Where is that transcript? Because the next one is June 15th, 2023. Let's see how long this one is. If I should take that too. Yeah, this is the safekeeping order. Because this is in June. By this time they know. By this time they know. Between this hearing and the next hearing is Rick is in full-blown psychosis, force-fed Haldol, and his perceived confessions have been leaked to the media. Not by the defense, by the prosecution. And Judge Gull does nothing. But that one is a really long hearing. So folks, I'm going to quit for now. Now, keep your eyes out, because what I'm going to do now is I need to have some dinner, maybe a nap. I might go on a new stream later today, but I will put it out at least an hour in advance if I do. Other than that, I will probably do a similar like this one tomorrow. In the meantime, I will also get this stream and cut it up in video format for the different readings of transcript I have done, so they are easily accessible. I will also cut out mine and Andy's discussion as a separate video. So you will have that to look forward to if you joined late. But for now, I need to save my voice, have dinner and everything, and either later today or tomorrow will be the next part of the trial transcripts. Thank you everybody for being here. Thank you for allowing me to do this. And I'm going to send you off with the Free Rick song. See you. Bye-bye.
Down in the shadows where the courthouse stands, a gavel cracks a fading hands. Judge Gould, they whisper with a crooked grin, played the game where justice don't win. Free Rick Allen, let him go. Chains on the innocent, don't you know? When the truth's been buried and the lies unfold, the fire in the people burns hot and cold. Prosecutor Mickelin with his papers tied wrote the tale that never saw light. Twisted words in a room of stone, left Rick Allen to stand alone. Who will answer? Who will pay? The sun don't rise on a judgment day. Free Rick Allen, let him go. Chains on the innocent, don't you know? When the truth's been buried and the lies unfold, the fire in the people burns hot and cold. Officer Holman, eyes like frost, drunk on power, the line got lost. Lock the doors, keep him inside, for justice limps where his footsteps stride.